Hi, and welcome to the Ada K Show. I am Ada K. Brown, and am currently a criminal justice major, and I'm a deaf courtroom commentator. Grab a cup of Java, and let's dive in. Good morning, everybody. Welcome. Today is Karen Reed. We have a lot of stuff that's going to happen today. I've got my notepad over here. Ooh, that was weird. And I got to get glasses on. I can't see. Oh, I don't like wearing these. But my other glasses are broke. So this is what we get. Good morning, Jesse. Hi, welcome. You're first in chat. So you get extra entries into the drawing for the afternoon for the end of month. You get extra. And I see a typo. I gotta fix. Gotta fix it. Gotta fix the typo. So it's an early morning for me. I did not sleep much last night. I couldn't go to sleep. This dang plantar fasciitis. Oh God, it's horrible. It's horrible. Okay, save it and fixed it. I fixed it before somebody told me. Good morning, June. Good morning. Good morning. Y'all are in like Flynn. We are waiting for the Karen Reed to, well, my thing's going crazy today. Waiting for Miss Karen Reed's trial to start. There is so much drama that is so deep. We'll go over it later today, but it doesn't even involve Karen herself. It involves Auntie Bev and the Attorney General and the lawyers who are representing the Office of Attorney General, or ADA, not Attorney General, Attorney District's office, and Auntie Bev. There is a lot of conflict going on in the House. So welcome, everybody. I'm getting ready to get the Karen Reed up on the screen. There we go. We already have the proverbial fan, but guess what? At least this time, we have some lights to go along with it. I want to give a shout out to Court TV. Thank you so much for this live feed. We can't do this without y'all. We can't. Thank you so very much. Ooh, I got to invite my interpreter. I forgot all about my interpreter. See if she can come in. See if she can hop in this morning. Let's see if she's even up this morning. So there's some Auntie Bev drama that we're going to have to deal with that we'll talk about in a minute. Let's see if my interpreter. Well, hello. I can't hear you. Can you interpret this morning? You make me nauseated with the camera moving. Okay, Karen Reed has today, tomorrow, and Friday morning very, very important motion hearing. And if you can interpret, it would be wonderful. But I can't hear you. Oh, there we go. I got it. Okay, I'll set you up. Send you the link. I sent you the art. That'll be wonderful. Sent you the link. I'll take you out a window when you interpret. You can pop yourself. All right, I'll explain. All right, okay. My interpreter has another job, but she is. Hi, Chris. Yay! Welcome. You get additional entries into the end of the month, but welcome. Love to have you. Oh, you're so awesome. Um, Diane will be popping in and out between interpreting jobs. She interprets for a college, so she'll be in and out. And if I need to, I'll start interpreting, but that means I won't be able to take notes. Yana, good morning. Will you please reach out to me after the live or just reach out to me in Discord real quick? Start a chain message with me. I wanted to ask you a few questions. My coffee is full. Let's see if I can drink it without spilling. Mm. Mm. I haven't even looked at Discord. Let me close that. Pull up my Discord. There it is. Good morning. I already caught it. Yana, thank you. I don't mind you ever sending me those kind of messages, but I fixed it and caught it. I caught it. I put that thing up like at midnight last night. I am so tired, y'all. This plantar fasciitis is not going away. It's been very painful. And not having my glasses has been painful too. Having to use cheaters. Yay! Hooray! I was laying down last night. Do these look bad, y'all? I was laying down last night and it went off in my head. Ding, 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 ding. You didn't set your live for tomorrow for Karen Reed. I freaked. I freaked. So I came back here. Yeah, I drove back here and set my live and drove back home. Oh, I gotta put that out. Oh, y'all, look what I have for the trial when they're talking about the solo cup. And then I also have that Camp PD evidence kit. So we have some fun things I'm starting to do. Really? These are native, and they have some that go way down here. They're very long. They're super lightweight. They're super lightweight. But these are made by Native American, and they're native pattern, the typical floral pattern for native regalia. Oh, I need to get pen and paper. Who's a real good note taker? Because I am going to be probably interpreting through part of this. So I need a good note taker. I need a note taker. I want my pencil. I don't want pen. Uh, Karen Reed. Today's the 4th already. That is all them. Not me, y'all. I don't know why they're banging on the mic. There's no reason for that. That's not how you test a microphone. Well, it ain't. I'm switching.
Cozy?
Oh, yeah. I'm having to switch because these glasses have a thicker frame than mine other ones, and people don't realize how much between the hearing aids and that make my ears stand out, and then those thick frames, it's uncomfortable. So these thick frames, along with the thinner, which means I got this mic cord behind me. Yay! And I'm not echoey. When I put my hearing aids in, I echo. That's why sometimes I sound funny because I'm hearing myself in an echo, in a delayed echo. So I'm getting everything ready. Y'all got your paper? Everybody ready? Do we have, are y'all ready for the note? I want to thank Miss Chris H. for your membership. Thank you so much for becoming a member to our community. We appreciate it and love you for it. Oh, coffee is a must, y'all, this morning. I'm hearing all kind of weird stuff, but I can't tell you what it is. Well, you're 6 minutes late, y'all. You're 6 minutes late. And I'm waiting for the interpreter to pop in. No, I didn't know we could do that. Yeah. Let me get up that information I was looking at earlier. They have 10 people coming in. Did you hear them? They said they had 10. Is that for Karen Reed's side or is that for Um, the other side. Oh, I love some of these headings. Listen to this. We're going to go down some Karen Reed headings. Numbers don't lie, but Jen McCabe does. The toll for living, the toll of living as a defendant on national stage is horrendous. That's true. Oh, there, I heard a pop up. There was a one that I started watching. I'll find it later because Miss Diane is in the house. Ready? Okay, Miss Diane. Okay, I'm just trying to get you centered.
Move some things, get some things
I'm
situated.
sorry. I'm sorry. Okay,
I
don't worry
can't hear you.
Oh, well,
Hold on.
I'm loud. I'm loud mouthing it.
Turn
Can
that
y'all
up.
hear this?
No.
Yeah, you're turned up.
Okay.
That would have been bad.
Okay, hear whatever's up on your screen.
I know. Gonna have to hang
I will
in.
tell you where you're facing now, and everything looks great. Don't worry about what you see in the thumbnail on the bottom.
Okay.
Circle
Yes.
is perfect.
Okay, hold on.
I'm muting you. I got you muted. You do your thing. Uh-oh, hold on. You will have to bring your hands up a little bit to your face me all the way with your body.
Bring me down, and I can turn this way.
Perfecto. All right, okay, y'all are gonna see Miss Diane doing double duty. I'm gonna go ahead and pop her off right now because she's on the other call. She's doing her daily job interpreting for a college student like she does for me. You get to see and then when she is not interpreting for a college student, like when they have some individual work time when the lecturer is not speaking, she will hop on over here. So yay for you, madam. I really appreciate her. She's amazing. I can't do this without her. Oh, I could. I don't want to. So everybody's waiting, like anxiously awaiting for this day to begin. No more than Karen Reed, I will tell you that. No more than Karen Reed is. That's for sure. I have off the topic questions. Okay. When I see signers on TV, I notice that they are always two and they switch off. Here's the question why? Because interpreting like we do um, takes extremely a lot of skill. And for example, to not wear out the interpreter. What happens is like right now, I'm going to show you what Diane's doing. She's interpreting for a student. They have found, because they put an ASL interpreter into an MRI or whatever they did, and they discovered that when you're interpreting, you use both sides of your brain at the same time. You're listening, you're holding the information for about 3 to 4 seconds, then you start changing it into ASL, and then you produce it while at the same time listening. There's this big loop. And the problem is you wear out mentally extremely quick, and physically. So usually interpreters switch off about every 15 minutes or so. Um, and also it's good for and one that's receiving the interpretation because you too can get a little bit zony watching the same interpreter all the time. But it's more to preserve the physical and mental while they are awaiting. Um, while we're waiting, let me get that back in front of me. Okay, so that is why. Number 1, mental fatigue on interpreting happens really quick. Physical fatigue happens pretty fast. Um, here's the challenge. I challenge you to try and watch a news broadcast. I want you to listen to what they're saying and 3 to 4 seconds start speaking exactly what you heard 3 or 4 seconds ago while continuing to listen and keep that loop going 3 to 4 seconds behind of what's being said. That's how I explain it to people. And when they try it, they go, "Oh my gosh, that's insanity." And I'm like, "Yeah." So it's for mental and physical fatigue. And a lot of interpreters, they don't just do that one little job and go home at the end of the day. They go from job to job to job if they're good and if they are lucky. There's your answer. Not a stupid one. Some people say it's a stupid question, but why do they? No. And it gives them a mental break. So Diane and I will be switching off some today. Anybody would love to take notes for me and send me a typed out version would be granted extensive extra credit for the drawing because I won't be able to take notes if I'm signing. Right now, we do not have an an ASL interpreter need, but they will be hopping on, I know, at some point. So I will need to. And in all honesty, court is much harder. Here she is working with her student, and well, depending on the class. If it's a calculus class, yes. Chemistry class, I couldn't do those. I tell them not my forte. Not my forte. Can't do that. Don't want to do it. No, thank you. I'll turn that down 7 ways from Sunday. Now, if it's something like a history class, I could do that. I mean, I just science science is not my skill set. My main skill set is concerts and worshiping, religious signing. I can do anything, but I love to do that. In fact, I'll be going to the CC Winan concert on Thursday night. I have a hard stop Thursday afternoon. I really hope that, I get to do some. Okay, which states have passed legislations on the daylight savings time and they adopt the permanent daylight savings time or opt out, but federal approved remains a barrier? Here's a lot of states. And of course, Texas is not one of them. Oregon, Washington, Idaho, Montana, Wyoming, Utah, Colorado, Tennessee, Louisiana, Alabama, Maine, Florida, South Carolina, Oklahoma, Minnesota, Illinois, Ohio, Kentucky, Mississippi, and Georgia. All of those states have abolished daylight savings time. Why can't we? I hate daylight savings. I wish I could because I'm trained and a certified peer support specialist. Oh, that's awesome. Oh, that's awesome. Amazing. Congratulations. Nope. California is not one. Of course, California is not one. One sunny day. Good morning. Good morning, everybody. So, just so we're getting a little window into her world. I wonder, I'm trying to see what she's signing. Yeah, that professor's speaking really fast. Yeah. It is hard. And legal interpreting is super hard because of the vocabulary and under a lot of law. I mean, in a lot of states, you have to have what's called a court certified interpreter, certificate, certification, including in Texas. And someone said, "Well, how can we interpret this?" Well, we are not in court. We are not a part of court. This is entertainment. And this is, like news or any other thing. But if we were physically in court, I could not interpret if a judge is present. If a judge is not present, then I can interpret. But as long as a judge is present, I cannot. And I do not want the responsibility because um, if you get the information wrong or that it's received, even if you sign it correctly, but the deaf person receives it in a wrong way or misunderstands, you have a liability. And I don't want that liability. I work for a European country. We have daylight savings time, Virginia, and then 3 weeks later, UK has it. Drives me nuts every year. I bet it does. It is. How are we to know who's in what time? Yeah, I just there's a federal get up and there's a federal hitch up, talk to your representatives, send letter, do what you do. Do what you're gonna do. My nose feels like I have a piece of cat fur on it. Kitty is doing better. She came out last night and she played like a fiend and then she hid this morning. So she's hiding again. I don't know why, but she's hiding. And like always, they're going to be late. We're ready at 8 o'clock and it is now 8:19 and we still do not have anybody in court. Er, I am so tired of hearing about the Oscars. No offense, y'all. The Oscars to me is a one night thing and shouldn't be. I understand the next everybody wants to see what everybody wore in clothing and everything, and that's cool to a point. But dang it, I'm so tired of it popping up on my feed. I'm tired of it popping up on my feed. Oh, the bald eagles that we watch have three little babies now. That is rare. One and two is normal, but three is kind of rare. Two is normal. Oh, huh. Look. I'm having a cup of our fabulous coffee. Might as well. Finally, finally what? Finally what? We still don't have anybody in court. I've got the feed up. We are caught up on time. So what is finally? While we're waiting, I'm going to go ahead and roll that beautiful coffee footage. Hey, y'all, please help me welcome the Hitchman Homestead Coffee. They are fabulous. They have many different blends of freshly roasted, freshly ground coffee. They have a monthly club where you get 4 bags for $40 or a Kirk option. Also, they just came out with a half and half. Oh my gosh, I absolutely love it. So do me a favor, go down to the link below at hitchmanhomestead.com, order you some coffee and show them some love. Here's my feed. I use Court TV. I don't like using other feeds. Good morning. Good morning. Good morning. The sound sucks. Good morning. Patience. We're here all day, y'all. Forget the cemetery trial, we'll do that tonight. No, what's today? Tuesday night? I have something tonight. Already coming out, smacking the defense. I'm ganged up. testing? I don't know, y'all. I have sound on everything.
I got 15 minutes.
You're on.
Yes. Let me turn you down. But I can't hear it.
Okay, I don't know why nobody can hear anything because I'm hearing it. I pull it up on my computer, I'm hearing it. I pull it up on my phone, I'm hearing it. It must be a YouTube thing. I
Yeah.
will re
Oh, Sarah's out. Sarah's out.
Can you hear it now?
No.
Huh? I don't know what's going on because it's not on my end.
Nope. I can hear you.
All right.
The defense has gone above and beyond its reciprocal discovery.
Okay, we're going to scoot
This
back.
was provided on February, a pause
All right,
email.
we
But when I
scooted
was
back.
looking through my notes, what you said was,
We got it.
based on that pause
YouTube.
email, I infer that there was no further discussion between Arthur and Mr. Jackson regarding compensation and
Thank
retainer.
you, guys.
And out of the blue, the bill arose.
I had to reboot
So
it.
my question to you is, are you inferring or do you know that to be fact? That there was no conversation, emails, texts, letters, phone calls? Do you know that to be fact? Or is that what you are inferring, as you said?
I am inferring, Your Honor, I do not know that as a fact.
Okay. So now my next question is regarding the invoice and the payment or fact of payment. So the invoice was provided on February 13th, 2025, provided to the Commonwealth. The bill itself was paid on July 25th, 2024. Why wasn't the record of payment produced at the same time
Same time as what, Your Honor?
as the invoice?
And you're referring to the record of payment being?
Yes, why wasn't the fact that this payment was made? It didn't come out, for me, at least for the court, until I asked you midway through your proceedings. And in fact, I have the opposite. I have filed after that February 13th date, and I know Ms. Little filed something yesterday to clarify this. It seems pretty clear. This was filed, I believe, on the weekend, February 16th. In the Commonwealth's defendant's opposition to the Commonwealth's motion to exclude employees of ARCA, the Commonwealth's motion to exclude these exculpatory expert witnesses who were not hired or paid for by the defense is not made in good faith in a desperate and transparent attempt to keep exculpatory testimony of neutral expert witnesses from reaching the jury in this case. Going on to the next page, ironically, the Commonwealth accuses the defendant of failing to comply with her discovery obligations while conceding that the information is not in her care, custody, or control. Moreover, here, the defense has gone above and beyond its reciprocal discovery obligations and has already satisfied all of its mandatory discovery obligations under Rule 14 and turned over all additional information in
She's
the
going to
control
talk
and
to him.
custody of the defense relating to the ARCA witnesses as ordered by the court at the last hearing, in spite of the fact that the defendant's reciprocal discovery is not yet due. How do you reconcile that? I had to ask you midway through your presentation whether that bill was paid.
I'm going to answer it, Your Honor. I just want to make sure you were finished with your
Go ahead.
question. I learned that invoice was paid Sunday night before February 18th. I'm going to repeat that. I learned.
You don't have
I'm
to
sorry.
repeat it. And again, what you know and what all counsel know is one and the same.
I understand, Your Honor. I want to, so I'm answering your question. That's part one of the answer. When that was submitted on the 16th, I had not gone and done my investigation and gone through and asked all the questions that I did. So that's part one. Part two of the answer is, Your Honor, you've referenced that I didn't get to the payment until the middle of my presentation. The reason is because I did my presentation in chronological order. And that's the notebook that I laid out. I started with March, went all the way through. And when I got to the invoice, before I could state that it was paid, Your Honor asked the question, was it paid? And my answer was right away, yes, it was paid. And I said, and that's what I was going to get to next. So the reason why it came out when it did is because I did the whole presentation in chronological order.
But the motion, defendant's opposition to the Commonwealth's motion to exclude employees of ARCA is signed by you.
Your Honor, it is signed by me, but if I could with regard to 3.3A1. 3.3A1 is not a strict liability statute. That's the reason why it has knowing in it, is in order to violate 3.3A1, the attorney in question has to know with regard to the fact and issue. So respectfully, Your Honor, I have a different view of what an attorney is responsible for under 3.3A1. You're absolutely correct. Under everything else, particularly Rule 14, it can be no excuse for any attorney, including me, that I didn't know what was happening in discovery. That's not the way Rule 14 works. I am responsible for everybody. But Your Honor, it's clear in the commentary, it's clear in the case law. The reason why knowing is with regard to each attorney is no attorney can be responsible for the statements of issues of fact in court when it comes to a 3.3A1 analysis. That analysis and construction, Your Honor, would render mere surplusage and read out the mens rea of knowing in something that critical of candor to the court. That's why they put the mens rea in, because no attorney can be responsible for a misstatement of fact of another attorney unless they have knowledge of the misstatement and they knowingly participate. So I respectfully have a different conclusion than Your Honor does about attorneys being responsible for statements on candor under 3.3A from everything else in the world, which I agree completely with Your Honor.
He just done pissed her
I'm
off.
not going to ask other counsel. All right, so let's move on to the next motion.
Your Honor, if I could, the tabs that I had, I marked them as exhibits. I didn't do that last time.
And the white book?
The weapon, and I had marked, Mr. Brennan has agreed to them going. May I just offer them in at this time? They're all marked. There are two. Your Honor's February 6th was exhibit 1. So I picked off on 2 and worked it out to 4. What would you like me to do with each, Your Honor?
You can hand them to the court officer, who'll hand them to the.
Well, there you are. Thank you. Thank you, Your Honor. And have you included what you?
Yes, but let's.
Okay.
Spicy.
Yes.
Thank you, Miss Diane. Everybody give some love and
Let's go
thank you.
on to your, did the Commonwealth want to add anything?
No, thank you, Your Honor.
God, I like more.
Let's go on, and I don't have to.
We keep our mouth shut. We're winning.
So the motion of the defendant to exclude the testimony of the Commonwealth's witness, James Crosby. And I read it 2 weeks ago when it came in, Mr. Leslie. I'll hear you on your motion.
Thank you, Your Honor. I'm just getting myself reoriented
Take your
back to
time.
it. Thank you.
Oh, spicy, right? That's how you spell spicy. Spicy. Yeah. Well, I can interpret that too. Diane, people were asking why do we switch off on interpreters, and I explained for physical and mental break because this is very hard work. Very hard. It's more mentally hard, I think, than physically hard. I can sign all day long if I know it and it's easy, but
May it please
I'm
the court?
this is hard.
The
No,
entire
it's easy. Okay.
proposed testimony of Dr. Crosby should be excluded because he is plainly not qualified to render the opinions that he is trying to render, and his methodology not only is not reliable, but it's not even documented. Your Honor well knows the inquiry under Dalbert Lanigan, so I won't go through Rentala and the rest. Your Honor's heard it many times before. Under the qualifications prong, the crucial inquiry, Your Honor set the standard for the subject matter of his testimony. And what is the subject matter of his testimony? The subject matter of his proposed testimony is the medical cause of the injuries and wounds to the right arm of the decedent. I'm going to get into how Dr. Crosby tries to camouflage to avoid the impact of the standard Your Honor established. But that is clearly what he is trying to do. And I cite to NDAO 1377, NDAO 1382, because that is where he renders his opinions. For example, he says, this is a preliminary response to your request for my professional expert opinion regarding injuries and defects to the right arm of decedent John O'Keefe. Similar statements. So it's very clear that's the subject matter of his testimony. Your Honor stated with regard to Dr. Rentschler that it is clear to me that in Massachusetts, biomechanical engineers are not qualified to testify as to medical causation of an injury. Point. Only an MD can do that. That's what Your Honor said was the clear law in Massachusetts. Admittedly, indisputably, Dr. Crosby is not a medical doctor. As a matter of fact, Dr. Crosby is not a veterinarian. He's not a forensic odontologist. And those are all disciplines that can even get near the type of subject matter that he's looking to opine about. He tries to dodge that very impactful standard that Your Honor established by saying, well, you know, this case is not about the treatment of the decedent. It's not a case about the treatment of the wounds on the right arm. And yeah, you have to be a medical doctor to treat, but that's not what the issue is, so I'm okay. It is a total straw man argument. He's creating this treatment. Nobody ever said the way that the issue is treatment. Dr. Russell never said treatment. Dr. Crosby made it up. So he creates this straw man to try to avoid the medical causation opinion that he is given. And I think that's a clear indication that he is very, very sensitive to the issue that he's not a medical doctor. With regard to his area of expertise, it can't be more obvious than his own proclamations. He says the name of his consulting group is Canine Aggression. His purported title is Certified Behavior Consultant. So he himself dubs himself with regard to canine behavior. And that is what he is expert in. And of course, there's no issue whatsoever in this case about canine behavior. And more importantly, his own report doesn't discuss canine behavior at all. So in conclusion, on the qualification prong, Your Honor, based upon Your Honor's standard, he's not a medical doctor. He's therefore not qualified to opine on the cause of the wounds to the decedent's right arm. The court need go no further than the qualifications prong to exclude all of his testimony, because all of his report is regarding the cause of the wounds to the decedent's right arm. And it almost is common sense that when someone is trying to opine on the cause, the medical cause of injury, that if you're not a doctor, with regard to the issue that you're not qualified. So now let's go to the methodology of Dr. Crosby. His methodology is essentially, he took measurements of one dog, a dog named Chloe, that it purports to be Chloe. He didn't document that it was. There's no documentation of that. But let's assume, hypothetically, it is this dog Chloe. So what does he do? He takes measurements. This is what he did first, and I'm going to get to what he's just recently submitted. So what does he do? He takes measurements, anesthetizes the dog, takes measurements of the teeth, and then he takes those measurements and he tries to apply them to photographs of the decedent's right arm. And he basically says in his methodology, I am measuring the distance between the canines, I'm taking other measurements of the dog's dentition, and then I'm going to compare them to the decedent's right arm in a photograph, and I am going to opine that the measurements of the dentition don't match up with the measurements and distance of the wounds on the right arm. Therefore, this dog couldn't have caused these injuries, and therefore these wounds are not caused by a dog. And this dog, so he says not only not Chloe, but no dog. Then he goes even further and he says, and I believe the cause is some sharp object. So now we have him going even beyond a dog, and he's claiming that it was caused by a sharp object. It just goes to show you how far he is afield of what he is doing. So he's not a medical doctor, so he's now performing essentially another diagnosis of the wounds to a human. He provides zero evidence of any experience in determining whether a wound on a human is caused by a dog or a sharp object. And his methodology, Your Honor, is remarkable for several other reasons. First, he uses a hospital wristband to take his measurements because the photographs of the autopsy didn't have the ABFO ruler in them. So he tries to use the wristband as a surrogate for his measurements. He provides no support whatsoever for using that surrogate. And what do I mean by support, Your Honor? For an expert to justify a methodology, they've got two ways to do it. The most prominent and common is that the methodology is generally accepted in the relevant scientific or medical field. He provides zero, and I mean zero, words to tether his methodology to a commonly accepted practice, meaning his methodology that he used, he doesn't show any support for that at all, let alone it's commonly accepted. He doesn't cite to one study. He doesn't cite to one scientific publication that says this is a permissible way to determine whether a bite is from a dog. So the burden, as Your Honor knows, is on the Commonwealth to establish the methodology. And I note, Your Honor, that the Commonwealth, in its first response, states in the third paragraph, Dr. Crosby engaged in recognized methodology to study the abrasions on John O'Keefe's arm. What recognized methodology? Where is it? It's not in his report, and it's not even in the opposition. So they try to brush over with a conclusory statement, Dr. Crosby engaged in recognized methodology, when it's nowhere in their opposition, where's the recognition for it? That dooms completely their second prong of Daubert. Then what they say about methodology in the same paragraph, they say the methodology employed was based on facts, science, and study. What do they cite to? They cite back to Exhibit 1, which is his report, which has not one footnote, not one reference in his report to support it. So the statement the methodology employed was based on fact, science, and study is a bald conclusion with no support at all. And this was the opportunity for the Commonwealth. I put it pretty clearly what the challenge was for them to come back and say, oh, no, the methodology, it's recognized, and here is the basis for it. It gets worse for the Commonwealth, Your Honor, on the methodology, because there are potentially some methodologies that might be used. They're called into serious question, but one of them for humans, not for dogs, is what the ABHO talks about is the dental mode and overlay method. And that is basically take a mold of dentition, and in the most recent submission, the Commonwealth put in, very belatedly, but I can deal with it, that Dr. Crosby now says he took molds of the dog's teeth. And so I'm going to accept arguendo that he did that and he did it correctly. But what he misses is those molds are meaningless unless you come to part 2. You've got to take those molds and compare it to something. And the something is what's called the overlay method. And what is the overlay method? And this is all set forth in our opposition. And I've got citations to the exhibits, which I'm going to go to. The overlay method is the part 2 you apply the mold to. So what you do is you take tissue samples of the wound and you make, there's a variety of techniques you can do, but you basically create the wound on a model, and then you compare the mold to the model to see if they match up or don't match up. He never engaged in the second part of what is, even with 2 parts, is a questionable methodology. He doesn't employ the overlay method, the part 2. So the molds that he took are meaningless unless you have the overlay to go with it, because that's what you compare them to. More importantly, the ABHO makes it clear that the only people that can do that are forensic odontologists. And even then, the science is very questionable. What he also does in terms of, and also for his methodology, where it's just a measurement, he provides 0 citations, and the Commonwealth provides 0 support for taking measurements in molds and comparing them to the wound. 0. So what are the other errors of Dr. Crosby? And these are not mere differences of opinion, Your Honor. These go right to the methodology. And we put in an affidavit of Dr. Russell, who is the medical support for his errors. So Dr. Russell goes through and talks about all the errors that Dr. Crosby caused in his analysis. The first, she says, is that he treated the arm of the decedent as if it is a static, plastic mannequin-like object. And what is meant by that? Your Honor may recall Dr. Russell stated that when anyone is attacked by a dog, they move their arm, they flex their arm, and they move it, etc. And that can cause a dog's teeth to have an incomplete bite, etc. Dr. Crosby doesn't account at all for that movement. So what he did was he treated the arm as if it never moved, and then he said, I'm going to take the dog's teeth, measure it, and then I'm going to take those measurements to a static arm. And he says it's just the distance is too far off to say that it was from any dog. Well, what he didn't account for is that when the arm flexes up, as it always happens in the defensive wound mode, those angles and those distances change. They get closer together. It's common sense, but it's also medically supported by Dr. Russell. And she said when you do that flex, that is going to make those wounds approximate the canine. But the fact is, her main point is he never accounted for that in his methodology. It's not an opinion. It's a methodology. So again, if he were to cite to a study that would say, no, it's okay to just treat it illogically as a static object, he might have some support, but he doesn't, and there is nothing in the literature because nobody believes that's at all realistic in a dog attack. So that's her first criticism of him. She also states that the photos that he used, there's no documentation of who took them, how they took them, and we all know in forensic photography, those people who take those photographs have to be trained. They have to give a fair and accurate depiction. And you can look at one of the key photos, it's blurred. So it's obvious that there's a problem with one of the photos. She also aptly points out that there's not one citation in his report to any support for anything that he did. The Commonwealth, in their opposition, spent more words going back trying to attack Dr. Russell than they did trying to support their own expert's opinion. And I just counted the lines. I'm not going to tell you what the count is, but there's more lines basically trying to say that Dr. Russell's entire testimony and opinions lacked adequate authority. My. She had, I think, 31 footnotes in her report. The one who entire opinions lacked adequate authority is Dr. Crosby. The other criticism that she has on the methodology of Dr. Crosby is that he didn't account for the dimpling and pinching and piercing of skin. Human skin, when there's any pressure, particularly with a bite, it moves, it dimples, it hits the muscles, etc., etc. He gave no account for the condition of human arm and skin and anatomy, perhaps because he's not a medical doctor and doesn't know the area. So with regard to the Commonwealth's response, I'm appreciative of the fact that they cited to his thesis. So what they say is in the second paragraph, they said his master thesis, the specific use of evidence in the investigation of fatal dog attacks, has been peer reviewed. So what did I do? I went and read both of his theses. What I found is particularly probative of the issues I just raised. So I looked at his and read his. I read 179 pages of his 2016 Master of Science thesis that they cited. In it, he talks about, on page 46, defining bite mark evidence. A bite mark can be generally defined as a pattern made by teeth in a substrate. A dog bite injury is a pattern industry. Your Honor may recall the absolute probing of Dr. Russell on patterns and the arguments that patterns are a soft science and you can't rely upon them. And lo and behold, Dr. Crosby's first sentence in his master's thesis is a bite mark can generally be defined as a pattern. A dog bite injury is a pattern injury. So I appreciate in his thesis that he confirms Dr. Russell's methodology. What he doesn't do in his thesis is even mention his own methodology that he used here. In 179 pages, There is now one reference to the methodology he used in his report. With regard to, I mentioned the ABFO, the American Board of Forensic Odontology, and I mentioned how difficult that is to do that correctly. In his thesis, he states, and I quote on page 61, the guidelines, however, do not indicate the criteria necessary for using each method to determine whether the bite mark can be related to a person's dentition and with what degree of probability. There is no science on the reproducibility of the different methods of analysis that lead to conclusions about the probability of a match. A very, and I couldn't agree with Dr. Crosby more on that. He then talks about, in his thesis, about the fact that there's no accepted methodology for dog bites, even using ABFO. And on page 63, I'm going to quote what he says. Although the ABFO does not specifically address animal bites, it would be logical to apply the same standards to forensic examination of dogs. And what is that standard? That's the mold in the overlay, right? He never did the overlay, and he was proposing in his thesis that that might be a way to go, but he recognizes that it is not reliable. And then on page 66, the last paragraph I'll cite in this, he says, reliability in human cases is under examination. Hard statistical agreement on consistency is not present, so each evaluator will have to make the best argument in each case. As case law develops and examination science progresses, we can hope that standards will be established and accepted. Until then, a forensic bite evaluator can best develop their opinion based on whether the bite mark in question is consistent or inconsistent with a pool of potential subjects established by other means. Here we go. This opinion should be heavily influenced by supportive hard evidence, such as DNA, physical observation, blood, tissue recovered from the gastrointestinal tract, and other factors. So the ABO, he agrees with the fact that you just, even with this methodology, you've got to have it supported by this hard evidence that he doesn't have anywhere near in his methodology. And what he also talks about is relying upon a medical examiner for this hard evidence. And what we point out in our opposition, Your Honor, he never worked with a medical examiner for his methodology. He never worked with a forensic odontologist. In the case law that we point out, even in this very suspect area of bite mark analysis, even in the cases that allow it for humans, they are all cases where there had to be a forensic odontologist or a medical examiner involved for quite obvious reasons. So his master's thesis supports the methodology of Dr. Russell and provides not one mention of his methodology. So then I said, well, maybe in his PhD thesis, which is more recent, 2023, maybe in that thesis that the Commonwealth did not cite. So I went and read 143 pages of that, and there is zero mention of his methodology, and that was just 2 years ago. So what does he say? In his whole thesis is entitled Dog Bite Related Human Fatalities in Scientific Study. So it's really about fatalities, and here it's undisputed that the decedent, his death wasn't caused by a dog. It's a dog attack, but that was not the cause of death. And his whole thesis is about the problem statement. He defines his thesis on page 18. One of the problems is the lack of standardization of methods and reporting. Lack of standardization manifests in several ways. So basically what he did in his thesis is he went through and talked all about when there's fatalities, there's ways, and he creates a classification system on page 63. But his classification is on behavior. Second sentence, page 63. Classifying dog bites. This provided the opportunity to develop a protocol for classifying the incident from the dog's likely perspective based on its behavior. That's his thesis. It's got nothing to do with, is this wound caused by a dog bite? And so on the point of needing a medical examiner, needing someone like a forensic pathologist to be involved, he agrees. Page 125 of his PhD thesis, first full paragraph. Where possible, medical examiners or other examining experts should document the location, extent of wounds, and try to determine which wounds may have been antemortem, perimortem, postmortem. This may require histological analysis by a forensic pathologist. So he mentions what medical examiners should do, what a forensic pathologist should do. He doesn't even begin to suggest that he should do it or that he is even qualified to do it. So in sum, Your Honor, with regard to Dr. Crosby, whose degree is in veterinary science, I don't know what that is. Dr. Russell doesn't know what that is. It's certainly not a veterinarian, although if one reads it quickly, one might think that's what it issued. He's not. He was a police officer for 22 years. And even then, he wasn't like a canine police officer. He had an interest in them then. And it wasn't until he retired that he became active in dog behavior and how dogs behave, if they're aggressive, et cetera, et cetera. So why is it, Your Honor, that we respectfully submit that he cannot testify with regard to the subject matter of his report, which is the medical cause of the wounds on the decedent's right arm? He's not a medical doctor. He's not a forensic odontologist. He's not a veterinarian. He has none of the qualifications. And he surely doesn't have any qualifications to say it wasn't a dog, but it's a sharp object. And then with regard to his methodology, he doesn't document at all how that methodology is generally accepted. He doesn't even, nor does the Commonwealth even talk about the non-exclusive Daubert factors and how they might satisfy that alternative. And lastly, when he speaks and writes a master's thesis and a PhD thesis of just 2 years ago, he doesn't even mention the methodology that he used. So, Your Honor, in Your Honor's opinion about Dr. Russell, stated that it was a close call for Dr. Russell in her ability to testify. If it was a close, no, not if, since it was a close call for Your Honor, I believe it is as distant a call as possibly could be made with Dr. Crosby. So I respectfully request that he be excluded. There's no need for a Daubert hearing. It's plain on the papers, and it's not something that is curable. The Commonwealth tried to submit very recently a mold. Interestingly, they never tried to document the methodology, tether it to study, show that it was recognized. They've now had 2 tries at it, and they haven't come close, and I'd urge the court to reject it. A jury should not have to hear from a dog behavioralist on what was the cause of the wounds to the right arm of the deceased.
All right, thank you very much. Mr. Brennan, before you begin, Dr. Crosby is not going to testify that this injury appeared to have been caused by some sharp object, is he? Are you planning on doing that in?
I wouldn't ask him to do that, no.
Okay. All right, so I'm going to
Yeah?
yes.
So was that a yes? Was she letting him in? Did she say yes?
Mr. Alisi tries to
Oh,
point out differences between Dr. Russell and Dr. Crosby, and there's always going to be differences between experts. One difference is that Dr. Crosby has actually testified in state and federal courts regarding dog bites before, where Dr. Russell never had before this case. And so in preparation for Dr. Russell, we provided not only a CV, a history of his education, but also an actual report. An actual report of what Dr. Crosby did, the methodology explaining his analysis, his examination of Chloe, and his testing. And that was provided to the defense prior to any testimony that he will have on the stand. When we look at the summary that's provided, Dr. Crosby has testified in numerous cases before. So those courts seem to disagree with Mr. Alisi's opinion. In addition, Dr. Crosby set out in his package numerous different journals and publications that he relied upon in this case. There are a number of publications, I won't read them all to the court, but we can see that he relied on books regarding bite mark evidence, human bites versus dog bites, forensic study of dog attacks on humans, a focus on bite mark analysis. The list is comprehensive: variable mechanisms of dog-related deaths, life-threatening dog attacks, a devastating combination of penetrating and blunt injuries, fatal and near-fatal animal bite injuries, on and on. These are materials that he has studied, he's familiar with. Dr. Crosby has the qualifications to testify, not simply because he's testified in state and federal courts before this case, but also because of his studies and his education. It seems as though Attorney Alisi is trying to bind the court regarding a comment of the necessity for a medical doctor. There is no requisite that an expert in this field needs to be a medical doctor. There is no cases that they provide that bind that limitation. The qualifications of Dr. Crosby are outstanding and significant. He studied at the College of Veterinary Medicine. He completed coursework in forensic animal behavior analysis, animal crime scene, bite mark analysis, veterinary forensic pathology, forensic crime scenes. He is often called to go to autopsies around the country to study wounds and determine if they are bite marks, if they are dog wounds, and if they can be attributed to a particular dog. He served as acting chief.
Is that in the papers?
The different autopsies he has, and I can supplement the autopsies he's been to, and I can also supplement specific cases where he's qualified. He has listed a number of cases in the back of his package.
So do I have the exhibits that I have are attached to the Commonwealth's,
Yep.
the defendant's motion.
They
So
have-
I don't know that I have all the reports.
Diane, are you available?
Exhibit 1 has Dr. Crosby's report that has all this information in it.
Okay.
And as I mentioned on a previous tape, Dr. Crosby actually went and examined Chloe. And when he did that, he verified that it was in fact Chloe. He did molds of Chloe, and there was a subsequent report regarding those molds, which clearly demonstrate that the distance in those wounds are not anywhere near consistent with Chloe's spacing in his teeth.
So sort of as an aside, based on what Mr. Leslie argued, the verification that it was in fact Chloe, has the Commonwealth provided that information to the defense?
We have, and we can provide that as a supplement to the court, the verification of Chloe, and we can also provide to the court the bite mold analysis report of Dr. Crosby, which is not in
I
this
have
package.
that, I think that's attached here, I have the photographs.
That's part of the original report, but then he actually took a mold of Chloe's jaw and teeth, and then I asked him to supplement a report regarding the mold.
And that's been provided to the defense?
It has, but it's not been provided in this package, so I can provide that to the court. So I'll supplement those two different items for the court's reference. In addition to his experience, he was chief of animal care protective services of the city of Jacksonville. He had oversight and approval of criminal investigations. He trained staff in dog bite and dangerous dog investigations. He served as the Animal Control Division Manager for Bay County, Florida from February 2008 to 2010. He has training and experience, including certifications in humane euthanasia of animals, legal restrictions of methods and reasons for euthanasia. He's investigated numerous complaints of dog bites, and dog behavior. He's published. I had shown the book to Dr. Russell when she was cross-examined. He has a number of engagements where he teaches. Dr. Crosby is well recognized in the field. He has employment in other projects other than his business. It includes a research associate canine brain project, 2023 to current. It's associated with Harvard University. duties include the investigation and documentation of dog bite and related human fatalities. Also, Division Management Consultant for Animal Care and Protective Services, City of Jacksonville in 2016. He is a professional dog trainer, behavioral consultant. He has provided expert witness testimony in cases of dog bite, dog attack, dog-related fatalities. Now, in Dr. Crosby's report, he outlines his methodology, and you can see it is specific, it is detailed, it is consistent. So when we compare, I'll refrain from getting into too much of a comparison, when we see the actual study of dog bites, we see something different in Dr. Crosby's report. They're not unsupported claims that change from time to time. You can see that there are the pictures of Mr. O'Keefe's arm, and we can see the band in which he used to measure. You can see multiple pictures of Chloe's jaw, mouth, teeth, canines, incisors, and then you can see that he has measured.
Did he just say incisors? We don't have incisors. We have incisors. And get your terminology right.
The distance of all of those teeth specifically.
Okay.
Then in his methodology, he outlines each group of lesions, specifically lesion group 1, lesion group 2. And then he goes into an analysis of the different groups of lesions. He explains why they are wholly inconsistent with both a dog bite and any animal bite. And he also describes and explains that the distance between the wounds are totally dissimilar to Chloe's mouth. He does look, as Mr. Lisi suggested, at other support, such as DNA. And in fact, he embraces other support. In this case, there is no canine DNA, significant to Dr. Crosby because in virtually every case,
there's pig DNA. And the only reason why there's a strong evidence of pig DNA is because the dog had been chewing on a rawhide before he bit the subject.
he finds canine DNA. So he does look to alternative sources, and mindful, there was pig DNA found. So it wasn't as if the sample was obliterated or destroyed and there was no materials available for testing. It's just the unfortunate
Where did the pig
consequence
DNA come from?
that there is no animal
Did
DNA.
you bite him?
And so while there are different methods, and some of the things that Attorney Lisa spoke about that should deal with human biting, not dog
If
biting,
not,
his methodology is set out very clearly on how he came to these determinations, what he did in his study. He actually engaged in an investigation in this case before providing his opinions. So Dr. Crosby is well qualified. He has been accepted in state and federal courts before this case. He did a thorough examination. He has ample support for his training and experience, and his opinions are soundly based, not on hypothetical or rhetoric, but on the facts, on the details in this case. He has never changed his position from one event to another. It has always been the same in this report, has not wavered, and he is highly qualified to appear in this case in rebuttal if necessary, if Dr. Russell is to take the stand and provide some or any of the opinions that she provided before.
All right, so just to be clear, the Commonwealth does not intend, if I permit the testimony, does not intend to call him in your case in chief?
Absolutely not.
All right, Mr. Leslie, any follow-up?
thank you, Your Honor. Thank you.
The Commonwealth did not address in its presentation, you heard one probative, legal or factual point I made because they can't specifically. The Commonwealth just stated that Dr. Crosby has testified in court numerous times. On what? It's important. You can be qualified to testify. And if it's what Dr. Crosby does on behavior, dog behavior, was the dog an aggressive dog? I get it. But the Commonwealth never said that in even one of those cases, Dr. Crosby testified on whether the cause of a wound was from a wound to a human was from a dog. Wasn't mentioned. There's no case provided. As best as I could, I looked at those cases. I couldn't find many of them, but I didn't see any indication that he testified and was allowed to testify that the cause of this wound on a human was from a dog or a specific dog. Point number 2. Mr. Brennan mentioned he cited numerous journals. Your Honor, I would ask the court to take a look at his report. There is now,
Hold on, so that's exhibit 1. and
yes,
4.
exactly.
Just give me a minute. Just put it back in.
Get him! Get him!
Right, so what page?
Every page. The point is, there's not one
Every page.
footnote in any of his reports. So he does go through his purported methodology. I've never said he didn't present a methodology. My point is, his methodology is not accepted, let alone generally accepted, and nowhere in his report does he say this methodology, this measurement methodology, is accepted at all. And you have to either show in Dalbert Lanigan that either your methodology is generally accepted in the relevant medical community, or that you can satisfy the Dalbert factors, which I'm going to get to. But Mr. Brennan said he cites to numerous journals. Your Honor, this is what Mr. Brennan has to be referring to. If Your Honor would please turn to the end of the report. This starts on NDAO 1400, very much toward the back.
Okay.
So he's got it in alphabetical order. Importantly, the page before 1399 at the bottom is entitled References and Materials Consulted That May Affect My Opinions in This Case. You can't have an expert report that does a data dump of references and says, there might be something in here that I might have considered that might affect my opinions in the case. And that's exactly what he did. And the only conclusion I draw from this is his methodology isn't in any of them, because if he had to cite which one of these contained his methodology, he would have to be creating fiction. So when Mr. Brennan says he cited numerous journals, well, he did, but where does he tether his methodology to one of them? He doesn't, because he can't, because his methodology, to the best of my research and Dr. Russell's, has never been accepted by anyone. So then what Mr. Brennan stated was that he participated in autopsies. My point exactly. He participated in them. He obviously doesn't perform autopsies, so it had to be with a medical examiner or forensic pathologist. He didn't do that in this case. There's no statement by him that he worked with a medical examiner, etc. So I think the inference the Commonwealth wants Your Honor to take is, because he's participated in autopsies, he must have been the one that determined whether or not the the wound is from a dog. There is zero evidence in any document from which even an inference can be taken. There's no foundation fact from which the inference can be taken that that's what he has done. He mentions a book that he tried to use on Dr. Russell and for whatever reason immediately truncated it. I will just reference that book is not peer reviewed, but importantly, nothing in the book that Dr. Crosby wrote, and I thank Mr. Brennan for bringing it up, there's nothing in that book that sets forth the methodology that he used here. It's not there. With regard to he's well recognized in the field, that's exactly what Mr. Brennan's words he just used. He's well recognized in the field. What field? For Dalbert, you gotta you got to have experience in the subject matter. I don't know what he means by field. Is it dogs, dog behavior? In Daubert, it's the subject matter, the testimony, which is what's the medical cause of the wounds to right arm. That's not documented. That's not even stated. He mentions Harvard, which people use for obvious reasons. You know, it's Harvard, but what is it that he is participating in Harvard in? This was from the words of Mr. Brennan, canine brain behavior. I didn't hear anything that he's at Harvard opining on the cause of wounds to humans and whether they're not from a dog. Mr. Brennan said that he outlines his methodology. I agree with Mr. Brennan on that. He does outline the methodology that he uses. But fatal and problematic is he doesn't tether it to a study to say it's generally accepted, which is the key inquiry under either Commonwealth v. Davis, common acceptance, or the Daubert-Lanigan, the 9 exclusive factors. And then the last point that Mr. Brennan made is particularly telling. He said Dr. Crosby bases his opinion on facts. That's not the Daubert inquiry. You've got to base your opinion on a reliable methodology. Facts, yeah, they are somewhat relevant, but the most probative aspect is methodology. So I am still, after all this time we've argued this, waiting to see where is the study, where is the documentation that the methodology that Dr. Crosby used, that a medical doctor, Dr. Russell, so thoroughly criticized, where is that methodology documented in one of these many references at the end, no footnotes in his study? I believe, and why isn't it, Mr. Brennan didn't respond at all to my points about Dr. Crosby's 2 theses, where you would expect his methodology to appear, and it's completely absent from there. So the question is, in conclusion, where is the home for his methodology? Where is the home? Where is the home in the scientific literature? It's an orphan methodology. It has no home because it's not generally accepted. So he is not qualified under Daubert-Lanigan, and his methodology is an orphan. And for those reasons, not only can he not testify with regard to whether the cause is a sharp object, but he has not, the Commonwealth hasn't even begun to meet its burden that his methodology is reliable for all the reasons that I have stated. And a good part of my position is based upon Dr. Crosby's own report that doesn't tether it to a study or general acceptance, and Dr. Crosby's own theses that don't even mention the methodology that he is trying to put forth in this case.
Oh, mic drop.
Briefly.
Where's my mic drop?
On page 6 and 7, Dr. Crosby offers court cases in which he has testified and provided expert opinion. I will give you specific cases where he's been qualified in state and federal court. Mr. Lisi harps on the idea of methodology. If we remember Dr. Russell's testimony, it wasn't until later in her testimony that she introduced this idea of pattern recognition analysis. And we hear very little about the
But she
details.
did
What we
introduce
do
it.
or learn from
Doesn't
Dr.
matter
Russell
when
is that she
or
can
where.
identify any of the wounds, none of them independently, just collectively. In fact, I think she opined that she was the only expert in the country that really could perfect the art of pattern recognition analysis. Attorney Lisi's arguments are the fact that he doesn't like the way Dr. Crosby wrote his report. But what I can say for Dr. Crosby is at least he wrote his own report. And when you look at Dr. Russell's affidavit in support, there's something, to be intellectually honest about it, striking. Kind of like her original report, where it was clear to me that it wasn't fully written by Dr. Russell. You look at that affidavit, it is not consistent with the testimony or the mannerism or the way that expert speaks. And so a lawyer can craft an affidavit and help craft a report so it meets their idiosyncrasies, but that is not the arbiter of somebody's qualified. Dr. Crosby is qualified, he has experience, he's testified and been accepted by courts before. Thank you.
Okay. So before we move on to the next motion, it was filed after the other motions that we finished here. It was filed on February 21st, I believe. Defense motion to exclude, February 21st. Defense motion to exclude certain testimony of Commonwealth witness Robert Gilman, and in the alternative of Daubert hearing. So the last time we were here, I wasn't sure we would reach this. I think it had just been filed. So I don't have an opposition from the Commonwealth. I don't know if you wrote one, if you planned on writing one, or if you just wanted to go forward, and also whether you're prepared to go forward today.
We do not have a written opposition, but we are prepared to go forward today.
Okay, so I will hear you. Mr. Leslie, this is you again, right?
It is, Your
All
Honor.
right, so I'll hear you.
He's like, dang it, I don't want to hear from you. He's like, I'm taking control of this.
And this is paper.
I am speaking on behalf of all the other attorneys. Because you
May
don't
it please the
like
court. Mr. Gilman, a meteorologist, is attempting to opine on the hardness of soil conditions at 34 Fairview on January 29th, early morning 2022.
Yeah, and
He states
this
in
joke,
what is
Diane. This
a
guy is
certified meteorologist, a certified weather statement.
beautiful
That's, quote,
today.
certified weather statement. Many things, and we don't challenge his statements about what the temperature was and precipitation. But what we do challenge is his opinion with regard to the hardness of the ground. With regard to his qualifications, his qualifications to opine on the hardness of the ground. He is not a geologist. He's not a pedologist, i.e. a soil scientist. There's a specific field for that. He's not a hydrogeologist, which is a scientific discipline that blends water movement in the subsurface, particularly the soil. He's not a hydrologist, which deals with solely movement of water, whether it's in any kind of media, soil, etc. And he doesn't purport to have any of those qualifications. He doesn't even state that he took courses in college that would have even educated him on soil hardness and the effect of precipitation with regard to the hardness of the ground. But perhaps the most telling statement that he makes is he puts his opinion in quotes.
What?
So his certified weather statement is hard as a rock, I believe. I'm looking for it.
So I'm sorry, there are a couple of exhibits attached to your affidavit, Mr. Leslie.
Yes.
All right, so one's exhibit 1, I don't.
Guys, I
see
could go
I'm
somewhere.
sorry, Your Honor. It's Exhibit 1.
Okay.
It's his February 3rd, 2025, quote, certified weather statement.
Okay.
That is it. And at the bottom of it, it's got in the quotes, the
Okay, I see it. All right. I don't see anything that says certified weather statement. It's an email, right?
no, his report is exhibit, well, it does state certified, and I'm quoting certified weather statement.
Is it NDA 02802 and 803?
It is exactly that.
Okay.
Yes. So, Your Honor, he puts his opinion in quotes, which to me is an indication he's speaking in lay terms. I've never seen an expert put an opinion in quotes. And he does not tether that opinion to any methodology. As a matter of fact, Your Honor, and that's the entire basis for what the Commonwealth is proffering is support that one, he's qualified, and two, that his methodology is reliable, but he doesn't even state what his methodology is that he used to come to that opinion. I've never seen a proffered expert not even state what the methodology is. He doesn't say how he came to that conclusion. So it's the burden, as we know, of the Commonwealth who's offering the witness to demonstrate by a preponderance of the evidence. They don't even have evidence, let alone a preponderance of the evidence. They don't state a methodology, and they put the key opinion, the only opinion, in quotes. And Your Honor, there is a deep and typical of science, complex way to determine hardness of ground. And he doesn't even begin to discuss that whole science. And Your Honor may recall in previous Dahlberg-Lanigan hearings, I cited to the Goodman case, the Pasteur case, and the courts in Massachusetts has said, in addition to going through making sure you've got a methodology, the court can also use it's the words of the court's common sense. So in addition to all the defects that I just covered, has anybody ever, all of us have heard a meteorologist in many different fora, most prominently on TV, talk. And what do they talk about? They talk about the weather, the forecast of the weather. What is the weather? We all know what it is. I've never heard a meteorologist say, today is going to be 22 degrees below freezing, there's going to be precipitation, and the ground is going to be hard as a rock. I've never heard it, because that's not what meteorologists do. So I believe in terms of common sense, in addition to the other arguments, I think common sense just tells one that this is not the kin of meteorologists. And interestingly, the Commonwealth doesn't cite and document one instance where Mr. Gilman has previously opined on the hardness of the ground. Not one. So in conclusion, Your Honor, he's not qualified in this area. He doesn't even state a methodology to come to the opinion, let alone show that if he had a methodology, it's reliable. He puts the opinion in quotes. I think the only reasonable conclusion from that is he's using layman, like an idiom, a term that people just use. You know, his head's as hard as a rock, whatever. But that's not science. And in order to give an opinion to the jury, the whole purpose of general acceptance, the whole purpose of Dahlberg, is it has to be based in science, and it has to be the methodology. There's none stated, and for that reason, and the others I've mentioned, Your Honor, Mr. Gilman, the meteorologist, should never reach a jury to talk about hardness of the ground.
Woo! Wow, preach it.
Mr. Brennan, the first question, do you intend to call this witness in your case in chief or for rebuttal?
I do, case in chief. Thank you.
By the way, real quick, for those of you who have not heard, Dolly Parton's husband at the age of 82 passed away yesterday. Just FYI. As I can.
The Commonwealth proposes calling this gentleman to talk about the weather conditions leading up to the night that John O'Keefe was killed.
Oh my God, are we going to hear 45,000 different Witnesses talk about how much snow and how cold it was. Oh my God.
Talk about the temperatures, the wind conditions, also the snowfall. It seems that the only complaint the defense has is the ultimate opinion that the ground at Fairview was hard as a rock. I think that that concern is easily remedied. I do not need to ask this expert if the ground at Fairview was hard as a rock. I can ask him about the documented temperatures, the winds, the snowfall, what makes the definition of a blizzard, how many hours have to elapse in certain conditions to be a blizzard. Also, he can measure the snowfall as it accumulated that night into the early morning hours because there's statistical evidence about it. And I would like him to talk about how ground freezes. Without giving an opinion that this ground was hard as a rock, he should be able to testify that over a period of time, the frost below freezes the ground. I don't need or would not ask Mr.
No.
Gilman to talk about the ground hard as a rock. We have a handful of first responders who will give lay opinions with common sense that the ground was.
They're not medical examiners. Oh, Yana. Weak sauce, applesauce.
Was hard as a rock.
Oh.
And state police who excavated can testify
Oh,
to
he's
that
still
very
gonna
thing.
get
So
his
Mr.
way.
Gilman does not need to offer that opinion. If that's the only thing offending the defense, I think we can resolve the issue.
Would you say that, Mr. Leslie?
We got a lot of reasons why we don't want this guy. We're just sticking to that one.
In specific answer to your question, Your Honor, what do I respond to that? I think the Commonwealth very much recognizes the shortcomings that I mentioned, but its proposal to have a meteorologist talk about how ground freezes is still very much problematic because, just by way of example, how a ground, whether it's frozen or not, and how it freezes, I will give, Your Honor, citations to scientific studies that address and techniques as to how one has to do that. Benjamin J.G. 2005, freeze thaw effects on penetrometer resistance in shear strength.
Why don't you propose it right? Was that just a Google search? I saw that you had it on your.
Actually, Your Honor, the answer is no, it's not a Google search. I actually consulted with the former head of the National Academy of Science on geology, Dr. Donald Siegel, who told me and gave how it is that one determines whether or not ground is even frozen.
Okay, so that would be helpful to me. Is there any objection to the Commonwealth to me getting that?
Not at all.
Happy to provide it, Your Honor.
Do you want to provide a copy to Commonwealth as well?
No,
I'd be pleased to provide a copy to the Commonwealth.
All right, so I'll take this under advisement.
of course you will, like everything else. Next.
So how long do each of you need to get me what you said you would get me? The Commonwealth, the articles, and the qualifications, or the cases and the qualifications of Dr. Crosby.
I can have that to you today.
Great, okay. And those articles, Mr. Leslie, that you were just citing, when can I get those?
Do you want all the citations or the articles themselves?
If you've got the articles, if you've got a copy that'll save me from having to find them and read them, that's fine. If you just give me the links, I can do that myself.
I'll get you the articles,
I'm
Your
back.
Honor, in the text, and it's probably going to take you 2
Hey,
or
back.
3 days.
Do you have the links? Do you have a list?
I've got a list right with me today.
Okay, so I'll take that. And that'll save you from having to print the articles.
You let me hand it to the court officer?
That would be great. And you'll provide it to the Commonwealth as well. Is that your only copy, Mr. Leslie? Did co-counsel have copies?
Oh, no, co-counsel doesn't have any of this, Your Honor.
Okay.
I just need to black out something here that's,
Sure. You don't have to do it right now. Do it before you leave.
I'll do it before I leave, Your
And
Honor.
that way
Thank you.
there, we'll see to it. Jim, can you get a copy made for everybody? All right, so now, because we're doing them in the order they came in, Commonwealth's motion to impose sanctions. This involves a transcript that I've read. I've listened to the actual recording. Maybe it makes sense to take a 15-20 minute recess. Now, does that make sense to everyone? Okay.
All right, so please.
Is the Commonwealth going to be
Okay, we're going to be on a quick recess. Let's talk about this. Oh my holy bleep. You can sign that one, Diane. Oh my holy bleep. Uh I'll turn your mic on, so if you want to say something, you can.
All right.
This is absolutely insane, y'all. So first we were talking about the ARCA witnesses, and I'm having a hard time keeping notes and trying to do everything at the same time. Okay. ARCA witness. This is the people that
Yeah.
the federal government hired ARCA to do some testing for them. And well, the defense said on the stand, when ARCA was on the stand, the defense said, have we met before? No. Have we paid you anything? They said no. And at the time, that was true. They hadn't paid them anything. And I think the distinction between the two things are, and it may have been an inaccurate question, but I think it was in all honesty. They did not pay for the investigation. The feds did by ARCA. ARCCA, I think. They did not pay for them to do the investigation. They didn't pay for the reports. They didn't pay for any of that. What they did pay them for were their travel expenses and their time on the stand. For this, they're going to be paid by somebody. And the feds are not going to pay them, ARCA, to come and testify in Karen Reed's case. KR, if you want to abbreviate it. So there was assertion to what's called the email. Oh, we're back.
All right, so the court, please.
Okay, that was a quick thing. Mr. Alfay is a civil litigation dynamo. He is. But if you notice, he doesn't have a whole lot of communication with. No, we're not muted.
Mute me,
Mute. Why?
because I don't know when I'm going to be back on this one.
That's okay. We're not back yet.
Oh, okay.
The thing is with ARCA is it's all about when they got paid and the expectation of payment. And I think at the time of trial, when the question was asked, they had not been paid. So that was not a lie. We're splitting hairs here. Auntie Bev is on a tear. I will tell you that. And I do not call her your honor or judge because I don't believe she deserves the title. Number 2 was the exclusion of James Crosby. He is for the prosecution, expert witness who is there to counteract the defense's Dr. Russell. So, yeah, I'm sorry. I gave you a word that was difficult. Counteract, opposite.
That's what I used, opposite.
And so I agree with the defense. He's not qualified. He is not, his methodology is not scientific, or is it proven? And the documentation is questionable. He's a self-labeled expert. And I agree. He may have testified in state and federal court, but is he testifying to dog bites specifically? And is he testifying as a behavioral expert? I think that's important. And then the situation with his thesis and everything. I agree with the defense on here. I think, though, the prosecution tried very hard to get him to sound more qualified than he was. We'll see what Aunt Bev, but he's not a medical doctor. He has observed autopsies. Guess what? I have too. It was interesting when I was going to my ASL training. The department for the American Sign Language is in the basement. On the floor above us, which was floor 1 or main floor, was mortuary science. And certain classrooms were excessively cold because we were below the morgue. And so I actually asked if I could observe an autopsy because I wanted to see the procedures. I wanted to learn the vocabulary. I wanted to be able, if needed be, to interpret that process. Believe it or not, I was very impressed. It's not a pretty sight, but if you can dissect a frog, it's not much different. It's just a bigger and it's a human. Well, people think it's real gory and bloody and all that. Well, they drain all that out before they so it's not as gruesome as if you're on a murder scene, which I have been on. So there's a big difference. So I'm just really scientific, I guess, in that way. I hate science, but seeing human bodies in different forms does not bother me, usually, unless it's an infant. So they're fighting over that. Then the third thing is, what I was getting to is just because I observed a autopsy does not mean I am an expert and giving expert opinions based off of what I saw in the autopsy. I can tell you what I saw, but that makes me an expert? No.
Hold on a minute. I'm off.
I got you. I'm muting you. I got you. And then a vet, he's not a veterinarian. I can take classes in veterinary science, but that does not make me a veterinarian. So that's where I struggle with this. Is there's a lot of questions in and out on this. You guys, we have only 6 people watching. All of you are watching. Can you please share? Please share. I really would like to grow, especially with this trial. So if you share today, and put I shared, I will give you extra entries into the drawing for the $50 gift card at the end of the month. And the winner of last month's needs to get a hold of me. I'll try and reach out to her again. Then we're coming on. I've done transcriptions for autopsies. It doesn't make me an expert at performing one, nor does it give expert opinion on them. Exactly, Yana. I have knowledge that doesn't make me an expert. Just because I have testified in court as an expert in one area does not make me an expert in another. The meteorologist, that one cracks me up, and I'm trying so hard to be a good girl. When you have somebody this guy is not a meteorologist. I mean, a meteorologist is not is not a geologist. I started taking geology and I was like, hell no, I ain't up for this. I was taking geology and they wanted us online to make all these drawings and be able to look at a fossil in the second week, be able to look at a fossil and tell you what conditions was it made under, what was the soil type, what was what. And I was like, I ain't doing this. This is not my cup of tea. Thank you very much. Appreciate you. But understand that doesn't make me a geologist because I took a part of a class or a class. And he is there to talk about what? What is he there to talk about? The thank you, oh sunny day, one sunny day. He's there to talk about the hardness of the ground. Dude, be right back. Okay, Yana. If you got wet snow on grass and then dirt and it's hard, the ground is going to be hard, but actually it could be potentially wet soft underneath all that snow because the snow is insulating it from the wind. in my humble opinion, and I'm not an expert. But ground is hard. I worked in a soil lab in college. Okay, K Swan, does that make you an expert on hard ground? God, you guys are impressing me with some of the things y'all have done. You guys have got to see the cutest Highlander baby born. Look at that baby. Oh my gosh, that is going to be a gorgeous Highlander. Wait till it turns around and I'll scroll up. Let me get it going again. Oh my God, it's the cutest Highlander I have ever seen. Look at that baby. Oh, that is so cute. I would own that thing. If I had a farm, I would be owning that thing. Um, so yes, if you want to have a meteorologist there to explain the conditions, that's fine, but he can't sit there and explain how long it takes for the body to freeze. That's not his expertise. Can he talk about how cold it was? Yes. Can he talk about how much snow it was? Yes. Can he talk about the weather previous and after that date? Yes. Can he talk about storm surges? Yes. Can he talk about a lot of weather stuff? Yes. But is he a scientific and the expert of ground? No. But I have a suspicion that Auntie Bev, by the way she came out this morning, is going to grant everything towards the prosecution. Defense is going to lose. Thank you so much for sharing. The defense is going to lose, again, lose their shirts on this as well. I don't think they're going to win anything. I would be shocked if they did. Um, I If y'all shared, put the I shared like this so it can get you. Put it in like I did so it can get you. Right now I only have one. I know other people have shared. So if you share, and please actually share. Right now, how many likes do I have? Let me refresh it. I got 10 likes. Yay! Yay! Y'all are awesome. I got 10 likes. We need to have more. I only have like 3 entries into the I liked. So if you liked, put I liked. We didn't use weather, people, to study moisture in the soil. I know moisture in the soil is not, thank you, Chris, is not, it's not meteorologist. Oh, thank you, June. You're so fabulous. I'm trying to get our numbers up. We always seem to stick around 7, 5. We need to get these numbers up, y'all. But anyway, this Auntie Bev is on a tear. It's crazy. Auntie Bev. I don't I don't understand this. Have y'all heard about the man with the golden arms? He's a grandfather whose rare blood saved millions of babies. Oh, snap. Oh, that hurt. Oh, yeah. I know that hurt your ears if my ears were hurting on that. Dang, y'all. That hurt. Ouch. That's on them. My apologies. Once I figured out where it was coming from. Oh my gosh, y'all. That was a big owie. Woo. Let me get so Auntie Bev, I call her, she's on a tear. She is literally on a tear.
No.
Oh my god. I am so glad to see another YouTuber eating. Wow, that was not what I wanted. There it is. I'm looking for more information, guys. Excuse my quiet. There's no way that Trooper Crawford could testify again in the second trial, right? Would it be embarrassed if I was in his position? Oh my god, yes. Thank you for joining us. Hey, K-Swan. Hey, Yana. Hey, Chris. Hey, June. I really agree with this one person. They said, I think after the jury is chosen, they need at least a couple hour course in juror education before the actual trial starts. I agree with that. But we are just in a position right now that this is just crazy. Okay. So I was looking at somebody else's stream because I wanted to hear what they were saying, and I'm not gonna go there. Yeah, she's not going to give them anything. I get so upset over her. Well, unfortunately, nothing we can do about it. I really have to say, I appreciate so much Karen Reed's attitude about all this. I appreciate the way she has talked, even in her interviews. She is not bashed. She's spoken truth, her truth, and integrity. I feel she's handled this with more integrity than I would be handling this. I'll be honest with you. I would not be as classy as she has been. But that said, I believe that this case is, how do I put this without being pissy? I think this case has drawn out the worst and the best of all of us. I think this case is a very difficult case. I think that the um, judge and her attitude and the way she has handled this case has perpetuated a lot of animosity and negative feelings. Auntie Bev has a lot more connections than we realize. I am going to find that information that I was hearing. I got to locate it, but apparently there was a filing where some attorneys were being retained for the Commonwealth, and that includes Auntie Bev. And those attorneys actually work in the attorney district's office. And how can you have somebody within your office representing you? That's conflict of interest. They should have somebody outside of their department representing them. So there's a lot of stuff going on behind the scenes. The I didn't know about, so it was crazy. Crazy, crazy. I didn't a lot of this stuff I didn't even know about. So, right now we are in a break. It's supposed to be a 15-minute break. Of course, it's gone longer than that. But, um, so I'm just kind of 7 months ago, 5 months ago. I'm looking for something specific. And that's sad because when you go to you don't realize that you're watching stuff, and then all of a sudden you go to a history and you can't find what you were watching, and I wanted to. I think that was yesterday. There it is, another bombshell conflict of interest. Okay, this is what I wanted to read to you guys. Let me go back. Okay, this was Karen Reed, writ of habeas corpus, full document, part 4. analyze your development and the read. Maybe you're already aware of it. Blah 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 blah. I want to put that up there. There is a conflict of interest, a blatant conflict of interest in the legal representation of the habeas filing. Let me go a little further. Let me see where it is. There are other, by the way, there are a few people who are describing this conflict of interest, but I'm just going to read a little bit here. We'll dive into it more. How can the state attorney general office use an attorney from Norfolk County DA's office to fairly review the trial court's Auntie Bev's court ruling in the Karen Reed case? From my position, and it looks like it's the prosecution and Judge Bev are working together to preclude Mrs. Reed from receiving a fair trial. That is somebody's position. The conflict, let's get a little closer. Let me see if I can read a little further. That to me is very interesting, and I never knew that. So, we are going to watch a show that was analyzed by somebody else, but I'm not gonna do it now. But I didn't know that. They had hired an attorney to represent them in the habeas corpus, and, um, that person is within their office. I'm like, "I don't understand that. How can you do that? What is the deal with that?" Let me see if there's a trend. Let me go there. Let me listen a little more. Mary, the accountability little spoke of this. So let me see. I'm trying to see if I can share this.
Now, the parties, the respondents to the petition are Norfolk County Superior Court, okay, the Superior Court, and the Massachusetts Attorney General. That's who the petition is directed towards. The person who filed the response to the petition is a special attorney general, and that special attorney general is, oh gosh, let me get his name right here.
Ipsy Dixit.
It's Caleb Schillinger, a special assistant attorney general who works at the Norfolk District Attorney's office.
He was their appellate lawyer.
Norfolk ADA. Why
it.
is he representing the interests of the court? And how is that not a problem when it comes to the partiality of that court? Now, the Norfolk County District Attorney is advancing and defending the interests of the court, and we're supposed to believe that the court is impartial with respect to this party. Now, how does this not create something of an appearance of impropriety?
Listen, the appearances of impropriety go all the way back to the motion to recuse, which I went over again last week. We read the decision for fun where she didn't recuse herself. There were so many appearances of impropriety between, the judge maybe knowing some of these parties. That's where the Auntie Bev came from when Sean McCabe, Matt McCabe's brother, wrote a text or a message to Turtle Boy saying, when Turtle Boy asked him, like, do you have an in to the judge? And he said, oh, Auntie Bev, whose beach house do you think we're going to bury your corpse under? That's where that came from. She was presented with those messages. She was presented with a Venmo transaction from between Ryan Nagel and Julie Nagel that said for Frank and Beverly, but it was spelled Beverley. And she said, I don't know them, and that's not how I spell my name. However, her husband's name happens to be Frank. There were so many things that gave her an opportunity to say, look, I don't know these people. I don't know. I don't know what this is, but it gives the appearance of impropriety. And for those reasons, I'm going to step back. I'm recusing myself. Peace out. She didn't do it.
No.
She had a lot of opportunities to do it. There was a motion to dismiss, or to a motion to disqualify District Attorney Michael Marcy for his egregious misconduct and that hostage video that he did. That was denied. There was a motion to dismiss the indictments based on all the shenanigans that happened during the grand jury and Proctor not, being forthright about his relationships with people, and Lank knowing the Alberts and getting them out of trouble for decades. Like, the tentacles of this case go so deep. It's like the roots of this family tree are so freaking twisted that you need like a Brandy Churchwell chart to even start to figure it out. Like,
Yeah.
what
Yeah.
are we-
And so it's just, it's so disillusioning because
What do y'all think about them apples? Yeah, that's concerning. Oh, sorry. What do y'all think about them apples? That's very concerning to me. I didn't know all that.
All right, so the next motion we have is the Commonwealth's motion to impose sanctions pursuant to Mass Work Criminal Procedure 48. Mr. Leslie, do you need a minute? Did you need a minute? I said just.
Could I please just?
Sure.
Thank you.
Jimmy?
Yes, I'm working on something.
No, not shocking at all.
Why don't I take a 5-minute?
All rise, please.
Oh, another 5-minute recess. Alrighty then. We'll hop back over here and I'll start interpreting some more. But I now, by the way, I'm very cautious about using other content creator stuff, but I thought this was so important. And I will give credit to these attorney Melody Little and Andrea Burkhart. But I want to interpret this because I have somebody watching.
and we're supposed to be able to justify this, and this is unjustifiable. What am I supposed to tell people? How am I supposed to explain this situation to my audience as if this is like okay and normal? You can't do that. You can't justify the unjustifiable, not if you're going to be, try to be the person that's dealing with this with some kind of integrity. And so it sucks.
Are you ready,
to be in a
Diane?
position where you have to be saying, this is messed up, and this is not how it's supposed to work, and this is unjust, and this is unfair, and this is not how the system is supposed to be. And yet, strangely, case after case after case keeps coming up.
And
Here
then to
we
be
are
like,
dealing with the same thing over and over and over again.
right. And then anyone who speaks out about it is personally taxed, doxxed. They've been trying to shut me up for over a year.
So this was the notice of appearance I did not see until today, and it was filed on February 26, 2025. And it reads Karen Reed, petitioner and respondents.
I hate the volume.
Superior Court and Massachusetts State Attorney. So this is a notice of appearance. It reads, please enter my appearance as counsel of record for the Massachusetts Attorney General as a respondent in the above captioned matter. And he is. The Massachusetts Attorney General is a respondent in the writ of habeas corpus in the federal case. Remember, when I read the writ of habeas corpus for you guys, the respondents are Norfolk County Superior Court, aka Judge Bev, and the Massachusetts State Attorney General. So the Massachusetts State Attorney General will not be there, apparently. They will be represented, or maybe they will be, I don't know, but more likely they will be represented by their attorney, Thomas E. Boshian, Assistant Attorney General, Appeals Division, Criminal Bureau, and it's in Boston, Massachusetts. So this is the notice of appearance for the State Attorney General's lawyer, his attorney, his counsel. Let's look at.
What do you think about them apples, y'all? Wow. I'm not going to watch 2 more of this right now. We'll do a special show on that. But is that not
As the
crazy?
court's aware, there are certain materials throughout the duration of this case that have been disclosed to the defense pursuant to protective orders. Protective orders are sacred. If there was no need for protective order, there wouldn't be a need for court intervention to protect the material. When an attorney violates Mass Rule of Criminal Procedure 48, the court can impose sanctions. In this instance, that was the genesis for this motion, there was recently provided materials that the court ordered the defense not to disclose to the public. Those materials, which is some of very important materials. In the reciprocal discovery motion, the defense put the materials into the public domain despite the court's protective order. Now, it's important for the court to determine the nature of that violation because the ability of the court to sanction is broad and wide. There have been other violations, but at this point, a month before trial, given the history of this case, it is important to make sure that these type of violations don't happen again. What stands out to me in the reciprocal discovery motion that the defense used as a vehicle to disseminate this information to the public is that they create an argument suggesting why it is important to include this information. In the memorandum, page 9, what they suggest to the court is because the trooper did not want to watch the closing, it implied that he had been following the entire trial. There's absolutely no reasonable interpretation whatsoever that because a witness, like any other witness who was not bound by a sequestration order at the time of closing, didn't want to watch a closing, there is no good faith basis whatsoever that that witness watched other parts of trial. It is an empty shell to make that suggestion, which then gives them the tunnel to put this information into the public. When you look at the nature of the information, it's obvious why the defense wants this information to the public. It's part of the consistent public relations campaign they have sought. It is a month before trial, and rather than discuss the facts and litigate the facts in front of the jury, it is a deliberate, ongoing, strategic investment to reach the potential jury pool. And it doesn't matter if it's attacking the trial court, the state police, the prosecutor, the prosecutor's office, witnesses.
Wow,
It
y'all.
is saturating
He's going for the
public
ball.
with sometimes
Oh,
disinformation,
honey.
parts of information that inevitably is going to make a juror's job much more harder. It is unfair to the court. It's unfair to the people of the Commonwealth. It's unfair to the Commonwealth. It's unfair to the prospective jurors. And so not only is there really not a logical or a reasonable basis to put this information in, but when we look at the nature of the information, it becomes clear. And so we turned over this information 3 times. We did turn it over as a text message, and notice of discovery 51, a protective order was issued, docket 416. We produced it, notice of discovery 57. And again, there was a protective order. And then finally, notice of discovery 58 with a protective order. This is just some of the materials. It is beyond dispute that the defense violated that protective order. So in considering sanctions, I ask Your Honor to consider the history of efforts by the defense in this case to disseminate information or to make statements that should not reach a prospective juror before this jury trial starts in less than a month. Now, after they disseminated this information, it wasn't within 24 hours. It was within 24 hours. This was in the local news, the national news, newspapers, online, and it seems that was the very purpose it was spit out into the community. And so the Commonwealth's position is there needs to be a sanction to stop violations of protective orders and violations of the rules of trying to convince the public before trial about a certain side's position.
Wow.
We've had a history in this case that predated me, docket 111, docket 262, where there have been efforts by the Commonwealth to stop, prevent extrajudicial statements. And despite that, it has not happened. There's never been a sanction by the court imposing an obligation for the defense to stop. Rule 3.6 is clear. A lawyer who's participating or has participated in the investigation or litigation of a matter shall not make an extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communications and will have a substantial likelihood of materiality prejudicing an adjudicative proceeding in that matter. It's important that all parties follow that rule. And there is no retort. The Commonwealth cannot fight fire with fire. I receive inquiries and calls, which I ignore and don't answer all the time because my obligation is a little bit different. It's to ensure a fair trial. Nevertheless, when these type of violations occur, there really is nothing to undo the taint. The history of these violations date back early on in the case, and they continue to this day. Fox 25, defense is quoted, certainly the Massachusetts State Police is involved. There are people that were in that house that are involved. Brian Albert is involved. Jennifer McCabe is involved. The rest of the folks that were in that house, there's some level of involvement by every one of them. Specifically, 3.6 is particularly concerned about disparaging witnesses, about giving a one-side opinion that may not be based in fact and truth about a witness. It is specifically concerned about the credibility of witnesses. There's been an ongoing promotion to talk about ARCA and federal witnesses and what the opinions are, which aren't in line with reality, the reports, or the testimony. It is a campaign. In addition to this recent protective order violation that got attention that money couldn't buy for a party, other information that was provided in our case, then provided in a collateral case, was again sent out to the public domain. The defense has not only trampled over 3.6, they've alluded continually about matters that have no basis in fact. January 18, 2024, District Attorney Morrissey is well aware he's a target of a federal investigation. We're aware of today's hearing in Norfolk County Superior Court in the Karen Reed matter. In connection with this matter, at no time has the U.S. Attorney's Office named any person or entity. That was the response by the U.S. Attorney's Office after they implied.
Where was that made? Where was the January 18th comment that you just said? Where was that made?
That was made by Mr. Yannetti, and I have a clip of it. He also appeared on court TV with Miss Reed. The Commonwealth is moving for a protective order for these letters after revealing part of what they contain. The Commonwealth wants to keep the remainder of the letters hidden because the letters contain information that will embarrass District Attorney Morrissey and his office. The letters demonstrate that he's a target of a federal investigation for what his office has done to Karen Reed.
Wow.
Where was that court TV?
Also toxic if you
I can
put
get the
I
date for
shared
Your
all
Honor.
one word, you'll be entered if you share the
Recently,
video. We need
on
to
February 18th, when we were arguing discovery motions, Attorney Little stood up, invoked the boogeyman, a federal investigation, attached themselves to the Birchmore case, and then proceeded to list off a number of troopers' names with no real association or relevance to any discovery motion. And this was a tactic to besmirch these hardworking, dedicated public servants simply by attaching them to a federal investigation for which there is no boundaries. Well, within 24 hours of those arguments, the Norfolk County District Attorney's Office was contacted by the United States Attorney's Office. And let me make crystal clear, they made clear that I could inform the court there is no longer any federal investigation into the investigation of John O'Keefe's death or any related matters. It is closed. It is over. So all those implications and innuendos that erode at the objectivity of our potential jury pool, well, they become more egregious when you see that they're not based on reality or fact. And so I submit that the ongoing, deliberate, purposeful poisoning of the potential jury pool is not only wrong and unfair, it needs to be stopped. And this last incident
Oh boy.
of taking a private email under a protective order and putting it in a pleading for the world to see is just yet another example. It's one small step in the marathon. Now, they've made their campaign clear why they're doing it and how they're going to do that. If there's any doubt whatsoever about the intentions of these tactics, I've submitted audio clips to you under seal, and I won't repeat what's in them. But that makes abundantly crystal clear why this is happening. And so, inevitably, the court has the ability to sanction. And as an aside, although an accused stands in a different or sits in a different position than the attorneys, grand jury minutes cannot be disseminated either. Not just the paper, in substance, they can't be. Doesn't matter who you are. And so the
Yes,
Commonwealth
good to
asks
see you,
the
Miss
court to consider
Toxic.
sanctions
Hello,
so that we
love.
can have a fair trial, so that it doesn't limit the parties. It's not retaliatory. We will
Rhonda,
abide by
thank you
the
for
same rules.
coming and commenting. Yes,
I suggest
I call it having a defense.
is that from now until trial, all pleadings submitted by the defense should be under seal so the court and the Commonwealth can
What?
review them and make any objections if there's any material that's private, so that there's no oversights or mistakes or dissemination of protected material. And then if the court and the Commonwealth does not have any objections, then those materials can be provided publicly on the docket. Also, the Commonwealth suggests that the court impose a sanction that the defense must follow Rule 3.6 as the Commonwealth does. No more symposiums on the courthouse stairs. No more interviews with national media. No more statements to press privately behind the scenes over a coffee, putting out information, oftentimes inaccurate.
Oh, are we making accusations? Holy
crap. Trial on fact.
Y'all. This is
There
getting
should
this.
be
I'm
a
looking
gag
for it,
order
y'all.
on all of these
I'm going to
attorneys,
find it because I
every
see
single
it.
one of them.
There it
And
is.
the Commonwealth will not speak either.
The bullshit meter just went to red.
Ms. Reed, I'm not asking for a gag order for it.
No, you want her to talk.
And so in light of the history
You want her
of
to
these
talk
repeated
because then you could
violations,
use it against her.
in light of the inability for the defense to restrain themselves, in light of their purposeful, intentional, and obvious efforts
Snap.
in order to best try to
He's
maintain
gotten
a fair jury
This is
in this
fiery.
case, is to impose those sanctions. And that's what I'm asking for. Thank you.
Oh, Lord have
Is
mercy.
anybody arguing this, you said?
Yes, Your Honor, may we approach this?
Oh, y'all. Somebody's gonna get in trouble. Somebody's gonna get in trouble. Oh, yep. We don't like what he said because then we don't get the scoop. OMG, y'all. Yeah. He wants everything out of the public. And they're wanting everything in public. See, I understand the worry about tainting the jury pool, but what about before? If you're worried about tainting the jury pool, good luck with that. You shouldn't have tried it again because this trial has gone so massively huge because of the mistrial that it is now worldwide. And good luck on finding a jury pool. Yep. I'm saying it. Good luck on finding it. You know, even without all that. I don't, oh gosh, y'all. Oh yeah, let's have everything put on the proceedings yeah, let's keep everything secret until we agree to release it as all three of us, the judge, the defense and the prosecution. Oh, I'm you know, I have to say, I know that Auntie Bev is really not going to do anything that's going to help the defense. Um, and it's my understanding that that it always errs in the side of the defense if it's questionable, but Auntie Bev doesn't give a crap about that. I think that it is, you know, so her and the Alberts have a relationship. Somebody Venmoed her and her husband money. Why is she even on this judge? Even with a hint of impropriety on her part, she should have recused herself, or someone should have forced her to recused. I don't get it, and I'm very frustrated. You guys, please pray for us in Texas. Um, we've got some severe weather and tornado possibilities in areas we normally don't. We normally don't. So I'm just saying, y'all. Yeah, this requires more light, not less. Yes, exactly. And the fact that he had the balls to bring up court TV and he brought up all that information on court TV. I'm all like, what, dude? You don't like the fact that court TV did an interview with them? That's too bad for you. Why don't you look at it as an opportunity to use it against her? I find it interesting they want to shut up all the legal team, but they don't want to shut her up. It's okay for her to say whatever she wants, but we want you to silence the attorneys. It's a crazy world. Oh, I forgot to do the sidebar.
Your Honor, as I mentioned at sidebar, I intend to make less of an argument here
Oh, he's
and
answering.
provide more of an explanation for the content of my motion regarding the reciprocal discovery. And at the outset, as I mentioned in court last week, this was indeed my motion. Mr. Jackson's name is listed first only because I used a template for the signature block, and that's why I'm addressing this today. And regarding the motion itself, I do acknowledge that I did not file a motion for impoundment when it was filed. And to the extent that that lack of impoundment is not congruous with the protective order, it was neither intentional nor willful. It was an oversight, not an attempt to flout any rules of this court. And while I do ask the court to take my word for that, I do also submit that there is evidence to back up that word. Specifically, I would note that one of the examples I cited in the motion deals with the testimony of a juvenile. And when discussing that testimony in the motion, I made sure to use initials, not full names, so as to protect the juvenile's identity and to
Oh, that
comply
never
with the
does.
court's protective
I'm
order.
sorry.
That's evidence that I did not intend to violate the protective order and that I was mindful of it in that instance. Regarding the communications involving Mr. Proctor, I frankly and simply did not connect that topic to the protective order when I was drafting it. It just did not register with me. It got by me. When I read Mr. Brennan's motion, I went back, looked at the protective order, And then it sure did connect with me. So I immediately called him, and I was transparent with him about what had happened. And so we get to the issue of whether sanctions are appropriate. And I recognize the court's discretion in this regard. With regard to this issue, I believe it is worth underscoring Mr. Brennan's reasons for seeking the protective order in the first place. He listed 3 reasons for the protective order when he filed the motion. And I quote his reasoning here. This order is necessary to effectuate the well-established privacy and safety interests of witnesses and to protect the integrity of ongoing investigations. So the Commonwealth sought to have this court issue the protective order to protect, number 1, privacy interests, number 2, safety interests, and number 3, preserving the integrity of other investigations. And I submit, Your Honor, those interests are all laudable. And I respectfully submit that my disclosure here did not undercut those interests. Regarding any privacy interests, Michael Proctor's opinions about Karen Reed and her attorneys have been well established and was well-known public knowledge as a result of the first trial. His opinions about my client and me were publicly aired at trial when his other text messages had come to light, inadvertently revealing that he feels the same way about Mr. Jackson that the public already knows that he feels about Ms. Reed and me.
That was
is a
all made public.
disclosure
He's right.
mistakenly that should be considered in light of the circumstances that already existed in the public domain, I would submit. And while the protective order covers this communication, I will note that it was certainly not an instance where I, flagrantly revealed or even inadvertently revealed social security numbers, addresses, dates of birth, private information to that effect. As for safety interests, which was the second reason for the motion for the protective order, revealing that Mr. Proctor has opinions about Mr. Jackson does not jeopardize or otherwise implicate his safety, I would submit. At all times during this investigation, and to the best of our knowledge, Michael Proctor is still a Massachusetts state trooper, and he's already on record with his well-publicized opinions as a result of the first trial, again, about Karen Reed's attorneys. So further information coming to light in this motion that he feels the same way about Mr. Jackson that he does about me does not move the needle, I would suggest, toward jeopardizing his safety at all. And finally,
He made
with
it
regard
public.
to the third reason for the protective order, I revealed no information about any other pending investigation. In this message, Mr. Proctor was strictly discussing Mr. Jackson. Mr. Jackson does not represent any other individual that Mr. Proctor or the Norfolk DA's office is investigating. He represents Ms. Reed. And so that message from Mr. Proctor was strictly about this investigation and no other. So, in conclusion, Your Honor, I told the court I'd be brief.
So the other
Protective
guy can
orders
say everything he wants and he has
serve
to be brief.
important and laudable purposes, and attorneys, including me, need to be diligent in abiding by them. I exercise diligence in abiding by the protective order that this communication got by me. The court will obviously determine the matter, and in making that determination, I simply ask that the court consider the interests of the protective order that were laid out by the Commonwealth and discussed by me here, and as well as whether there is a degree of prejudice that would warrant a sanction. Thank you.
So he took responsibility for some of it.
Disclosure of grand jury minutes.
I am prepared to do that. If Mr. Brennan is resting on his written submissions, then I can give my oral argument now.
Mr. Brennan, you already argued this, right?
I did, and I do have concerns about my ongoing obligations, so perhaps I could have a moment silent.
Ah. Sidebar. Are y'all hearing that? Because I'm using a different sound thing. So did you hear the sidebar? And
All right, let's just admit it. That didn't happen.
I got some cool, fun things for the new trial, and I'm trying to get everything up and running for trial because I think that's so cool. Yay! We have that.
This guy was good. All right, let's just admit it. That didn't happen.
No.
Wait.
You bastards. Sidebar.
All right, let's just admit it. That didn't happen.
Let's see what else I have.
When all else fails, read the instruction. All I ask is a chance to prove that money can't make me happy.
Howdy, soldier.
You can't really think about life. Just gotta let it happen.
So we got some fun things. Then I got some music. And when we need to chill, well, it's not playing. I don't hear it. I'll fix it. Got some native flute. I need to record my own native flute. I like mine better than theirs, some of theirs. Oh, so why is catapult coming up? I don't want catapult coming up. Let me get over here and fix native flute. The sound all the way. Fade in and out. Why does it not want to play? It is on the right. There it is. See, that's when we need to be calm, when we need to calm down. We need to calm down. So I got a bunch of fun stuff for us. We are on a little bit of a break, little sidebar break. But basically what just happened was Attorney Jackson just basically said, oops, my bad. I didn't realize that when I filed the motion, that was an oversight. I did not use the names. I used initials. The defense intended to disregard the prohibited. They did not intend to disregard it. Called Brennan. It said basically it was just oversight on the protective order. The thing when he's starting to talk about Michael Proctor and the comments made about him, it has been known well before the first trial how Michael Proctor feels about Karen Reed and the attorneys. So whatever stemmed from what he said in a public court that was publicized, I mean, it was Yannetti, excuse me. Yannetti. I get those two confirmed. Thank you so much, Yana. But Mr. Yannetti, that Michael Trooper Proctor very well knows that everybody knows because of what he said. I mean, he said a lot of really bad things about her, and that's part of the reason why he's in trouble. So with regards to that, I don't see how that what should have been in any kind of order preserving I don't see how it affected his safety. I don't see how it jeopardized the case in any of it. What are your thoughts? I don't understand it. I just think that they're just trying so hard, a prosecution, to tie the hands of the defense. On the protective order. And the fact that he brought up that Karen Reed has spoken in an interview with Court TV. She's not under any kind of a protective order or, or gag order or whatever you want to call it. And the prosecution flat out said, she didn't, it's not her, it's the lawyers. So we'll see where we go. What are y'all's opinion? Oh, I wish I had more sleep last night. Do you know when you know that you have to get up extra early and you know you need to get good sleep? You never do. You never do. I love it. I'm watching Diane interpret over here. I want you to see this. It is so funny. She's sitting here. She's interpreting, right? And when there's a spot where she's not interpreting, she's filing her nails. Who is this guy? Somebody just came in. She really does. Uh-huh. You got that right. You got that right. You were so right. She has such an amazing team, the best that money can buy, or no money can buy. And I think you're right. I think he knows that the only way he can win this is to attack the team, break down the team, and attack the witnesses, and to get as many of the expert witnesses out of the trial, and then turn around and then attack from that. He's going for the Achilles heel, which is the attorneys and the expert witnesses. I'm going to be interested to see how he presents his evidence versus, Lally. So it's going to be interesting to see the difference in their methods and their madness. Oh my gosh, I need to get something to eat. I haven't even had breakfast yet. And I wish I had milk. I'd have me some cereal. I'm out of milk. So I'm hankering for some milk. I want some cereal. I'm hankering. I'm on prednisone, unfortunately, because I'm having a flare up and it just makes me want to graze all day long. My stomach knows it's not hungry, but my mind wants to eat. I agree. The case is such an embarrassment. L.E. Brandon Walsh wanted to get his case dismissed before Proctor. It's all gone horribly. I can't believe it. Okay, do me a favor. Oh, I didn't mean to leave her up there. Hey, Matt. Okay. So, did Brian Walsh? I don't even know. I haven't followed that. Did Walsh get it dismissed? What's in say? Hi, baby. You coming underneath my desk where you shouldn't be right now? This case has gone 7 ways crazy from Saturday. I know he did not. Okay, I didn't think so. I hadn't heard about it. But what's going on with Trooper Proctor? Because that's pretty sealed. He's supposed to have, I think this week, he's supposed to have another, he's in another hearing this week on his job. I think they're doing that again. Oh, that's right. Proctor worked his case. That's right. That's right. That's right. Sorry. My brain is engaged so much into one. I'm having a trouble switching over to another. But Trooper Proctor, his hearing is still going on, and I think that they're supposed to meet this week. I could be wrong. And say, what are you doing? Lay down. If you're going to be under there, lay down. 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 Come on, lay down. Girl wouldn't listen to me. She just looking at me like I'm crazy. Dog. I love my puppers. So I want to listen to something. So the attorney who is representing the Massachusetts State Attorney General is the same attorney who is representing the Norfolk County Superior Court. Isn't that a conflict of interest? If you're representing the Superior Court and you're representing the same county attorney general in an investigation or motion or hearing, isn't that a conflict of interest? Why is he permitted to do that? I'm sure it is affecting the entire department. It's an embarrassment to that department. This department, I mean, if you really think about it, I really feel bad for anybody that's even in Canton. You say the word Canton, anybody who knows anything that's going on with this case is going to go, mm-hmm. It's negative. And maybe it's time. If that corruption is in fact there, you hear what I mean? If in fact the corruption is there, then they deserve it. 100% deserve it. Oh, that was, ow. I'm hung. Hold on, guys. Oh, that hurt. Oh my God, did that hurt? My tether got stuck on the wheels of my chair, and I thought it was gonna rip my ears out. Ow, that hurt. Oh, it's like being hung, but from the ears. Yeah, how can one attorney represent the Massachusetts State Attorney General's office and represent the Massachusetts Judicial Court, Superior Court in this filing from Karen Reed? So in the notice of appearance submitted on the 26th of this February, says, please enter my appearance as counsel of record for the Norfolk Superior Court, a respondent in the above matter, Thomas E. Boykin, the same attorney that's representing the state attorney general in the previous hearing. Why? Do they not have anybody else? I'm confused. So that to me is okay. And then you have the notice of appearance. Please enter my notice of appearance for the counsel for the Norfolk Superior Court. Respectfully submitted to Schillinger, who is also representing both. What? February 26th it was submitted. So he is a special assistant attorney general, and he's assistant Norfolk district attorney at and he's in the district attorney's office. How can you have someone involved in the case? You have the district attorney in an office of district attorneys that's going through a case. So you have somebody within the district attorney's office representing the district attorney's office and the Norfolk Superior Court. How can that be? How can that not be a conflict of interest? This is new to me, and I'm very perplexed. I'm looking at the document. I don't understand. You had to testify today? Oh my god. So the person responsible for the cover up has an attorney from the same office of the cover up. What the hell is going on over there? You've got to have more district attorneys. And if for some reason you don't, you pull from another county. You can pull from another jurisdiction. Dawn, I won't ask why you have to testify before a grand jury today, but baby girl, just go in there and do your thing. Don't get nervous. It's okay. A lot of people freak out when they have to testify. I've testified so much it doesn't bother me anymore. You're just getting up there and telling your truth. That's it. They can't hurt you. They can't bite you. They can't have you for lunch. So the same attorney that's representing the Norfolk County District Superior Court is also representing Auntie Bev at the same time. You have one attorney representing Auntie Bev and the Superior Court and the ADA for that county. What? I don't understand. Oh, it is in La La Land. So Boshian's upper so Boshian is representing the ADA, the Attorney District, office, Auntie Bev, and the Norfolk Superior Court. All 3. And it's from the same office. Mind blown. It's gonna be interesting. So, I don't know when all this hearing is gonna go off, but it's gonna go off. I wish it was gonna be publicized. I don't understand. Does anybody have any idea? I'm sorry, I'm looking at document. So Wednesday is going to be the hearing on this, and Weinberg is going to be there along with the other attorneys. This is going to be I don't know which of the attorneys are gonna be there for Karen Reed, but I hope all of them are. Tomorrow is going to be a show. It is going to be a show. I wonder if I wonder if the defense team is what they're going to say about the same attorney representing the ADA's office, the Superior Court, and Auntie-Bev, all 3 at the same time. Conflict of interest much? Get somebody from the outside. I don't understand. See, the Superior Court is AKA Judge Bev, by the way. It's all one. I'm not trying to be mean. Yeah, who gives a crap? Where did they get their law degree? What do they not understand conflict of interest? You're throwing all the laws in the books that you can at the defense, but yet at the same time, you have a special appointed DA who's representing the Norfolk Superior Court, which is anti-Bev and representing the ADA in this habeas corpus. What in the hell is going on over there? Cracker Jack box, yeah, but there's no prize in it. There's no fun prize in it. I love Cracker Jack boxes when I was a kid. I just get it for the prize. My brother would eat it. I take the prize out and I give it to him to eat, and he'd get mad because there was no prize. I said, well, it was mine. I gave you what was left of mine. It wasn't yours. You could get your own and get your own prize and eat it too. Oh gosh, guys, I got to do something I don't want to do, but I'm going to have to. Is it plugged in? Oh, yay. I'm having to get the heating pad on my foot. Ice didn't help. I have a really extremely bad case of plantar fasciitis. And I guess because of arthritis on top of that, in my foot. And I was told by a wonderful nurse practitioner who's taken my ASL classes to and I did it. And I believe it does work, but I had an old, like your Coke bottle, a little one about like that big, well, soda bottle, water bottle, whatever, and fill it half with water and freeze it and then roll it under the foot. I did that. And it relieved, I think, some of the inflammation, but what it did not relieve was the discomfort and pain because of the RA. So I am having a massive flare up. So it's no fun. Oh, sunny day. Um, so just so you guys know, we are under a Oh, that's a heavy, heavy one. Okay. Oh no, it's fine. It's like I'm cold and hot at the same time. We are having up to 50-mile-an-hour winds here, gust. We are in a massive fire warning, although there's always some idiot who thinks that it's okay because there's no rain to burn. I'll tell you what, if I have to go and respond to a fire and it was started by someone trying to do a control burn, I will go unglued on them. It's horrible. I mean, the fire conditions here are so bad, they have brought in people from out of state. Yes, they have. Yes, they have. It's interesting. Now that I'm getting ready to graduate, I'm getting all kind of cool stuff on my phone and in my computer about graduation regalia. Some of the things that you can get. It's interesting. Very interesting. Yeah, I know. I can't believe that I'm already getting ready this summer. Towards the end of summer, I'm going to be applying for graduation. I'm just excited. I started this journey last semester. And to think in 3 semesters in a summer and a fall, I have gotten my degree, my bachelor's. I am so happy. So the master's, I'll be going and taking my master's after this. Dolly Parton shares a heartbreaking statement after her husband Carl Dean died at the age of 82. I think she's 80. So I will tell you, when Dolly Parton passes away, I will be one very grieved person. I may never get to see her again in person, but I have spent probably about 3-4 hours in her presence over several different interactions with her. And I have to say, there are very few people in the world
that I can say. They're exactly as they are on TV that you see in person. Um, so last night we had somebody that was being chased by the police in this little small town. I don't know if they've caught them. So if you live in our community, please go to the Facebook page of the KPD and you will see who is being searched. And it is definitely armed and dangerous. So anyway, they were married 60 years. It is, she how do I put this? It is gonna be gut-wrenching for her, and she, one thing about her, she's super resilient. 2, they lived life where, when she's on the road, he stayed home. So she's really, really gonna miss him when she gets home, and, that's when it's gonna hit her. Out on the road, I don't think it'll hit her nearly as much, unless they talked every day, which think that, they probably talked a lot, but, a lot of people gave them both of them hell because he chose to stay private and she chose to be the public one. And you know what? That marriage worked for 60 years. So go get them. I think that's wonderful. They did what worked for them, and that's what's important. And everybody needs to respect that. Um, uh, so, poor Dolly. I know that's very difficult for her. And my prayers are with her and her family. They did not have children. Um, they did not have any children. So she says, all of us are her children. So with that, Dolly, our hearts and prayers go out to you. Also, the Pope is still in a very precarious condition. Here they come back. So prayer for him as well.
All right, Mr. Mayor,
And
go
his
right ahead.
followers.
Thank you, Your Honor, and thanks to the court for allowing me to make much of my argument at sidebar. The only remaining argument that I can make in.
We did that because that was material that needed to be done at sidebar.
Oh, I understand, Judge. No, and I'm
Just
thinking.
want the record to be clear.
I understand, and I'm thanking the court for that. The only other argument that I'd like to make, and this is appropriate to make in public, because there were allegations that I believe, misconduct regarding the existence or non-existence of the federal investigation, specifically directed at Ms. Little. The timeline is important here as well. Mr. Brennan himself was provided and sent a letter on January 30th of 2025. The letter was directed to him specifically. We obviously received a copy of it. And in that letter on January 30th of 2025, the first assistant U.S. attorney, Mary Moraine, informed Mr. Brennan that the federal investigation was ongoing. Those are her words. Mr. Brennan knew that. It was after that letter, I think within about 3 weeks, we were in this courtroom, and Ms. Little had mentioned the ongoing nature of the federal investigation. Not only was that truthful, that came from the horse's mouth. It came directly from the U.S. Attorney's Office, and Mr. Brennan was aware of that because he personally got the letter. It was only after that that Mr. Brennan has reported to the court that the federal investigation later was closed.
Can you give me dates again, please? So what was the date that Ms. Little made that statement? And what was the date that you all found out about the, what Mr. Brennan just announced?
Okay, so January 30th was the letter. We believe February 18th, when we were before this court, was when Ms. Little made that statement. And then it was thereafter, I can't speak to when Mr. Brennan says that the federal authorities contacted him, but it was after February 18th.
When did you hear the information? When did you hear the information that Mr. Brennan just told us?
Mr. Brennan called me to inform me of that. I don't remember the date. Maybe perhaps he can tell the court when that was.
Was it prior to February 18th?
No, it was after February 18th. Yeah, no, it was definitely after February 18th. Ms. Little reported the freshest information that we had truthfully to the court. Just in closing, Judge, this was not a boogeyman. The federal investigation existed. It was confirmed to have existed multiple times as late as January 30th, and it's right there in black and white.
Any follow-up, Mr. Brennan?
Ms. Little made her argument on February 18th. The Norfolk County District Attorney's Office was contacted about 24 hours later on February 19th. I gave written notice and called Attorney Yannetti on February 26th. The import of the argument is not that the defense was aware it was closed and continued to persist. It is insinuating and suggesting for years of this amorphous impropriety. It is trying to bootstrap their arguments, claiming, yes, that there's a boogeyman, that something is happening in the federal court, but they can't talk about it, when the reality is now that that case is closed.
If I may just briefly respond, Judge. I'd like the court to take particular care when we're talking about extrajudicial statements, not to take into account statements that were made in advocacy in court to Your Honor. The Commonwealth referenced a statement that I had made regarding the federal investigation. That was in a courtroom setting. It was not an extrajudicial statement.
Also, under the umbrella of the rules of professional responsibility.
Correct.
Court TV was not in the courtroom.
Oh, come on, quit with this pissing and moaning back and forth.
Okay. Thank you. So what I'd like to do now, the new motions that were really just filed.
She's not going to rule on anything
One
today.
has a response. So it's the motion to amend the scheduling order to give the defendant a little bit more time for their motion to dismiss and the Commonwealth's opposition. I would like to hear that now. I need to give him a minute. The parties have any problem in hearing that motion now? It is a
No, Your Honor, I think it's very
motion.
brief.
All right, so I need 1 minute, Mr. Jackson. Can you write it to me the ones from this morning, the new ones?
Who's going to argue? Oh, look at the smiles, their faces. Y'all be in prayer for my daughter. Their college area is at a high risk for tornadoes, and they have put them under tornado protocol.
All right, so you're both prepared to argue this motion, right? The motion and the opposition?
I'm so sorry.
So both sides are prepared to argue this, the motion to amend the court scheduling order?
Yes.
And the opposition, is the Commonwealth prepared in the opposition?
Your Honor, we filed an opposition and just informed defense counsel if they're looking for a date this week at the
court's available. I just don't want this to linger because.
So I'm happy to do that. The 17th is out. It's way too far away. But I will hear you. I know what I think is a reasonable date, but I will hear you to see if you need more time than what I think is reasonable.
I'll agree if they need a few more days without opposition.
Given that, may I, speak
Yes.
with council? May I address the court, Your Honor?
Okay.
Thank you. Very briefly, and I appreciate Mr. Brennan's accommodation. We received on Friday about 400 pages of new discovery, including most of it is probably not attendant to the motion to dismiss, but there are several reports, I think about 4 reports from Trooper Buchanan, Officer D. Jim Petro, D.I. capital G.I.A.M. Pietro, and 2 reports from Lieutenant Tully that are specifically attendant to the issues involved in the motion to dismiss. And then last night we got additional videos, video evidence, both 9 videos
San
of
Angelo
the
State University.
download process of Sallyport videos, and then about another 15 actual videos. I basically,
What's the quality of those videos? Are they poor quality?
I wish I could tell you. One of them came in, one of the batches came in after I was already asleep last night. I think it came in probably 10 or 11 last night, and I didn't see it until this morning. I've not looked at any of them.
Has anyone on the defense team looked at them?
I know Ms. Little was,
Your Honor, I briefly looked at them. It took about an hour last night at 9:30 p.m. to download everything. I cannot represent to the court that I've gone through in detail. I saw what was there. I'm generally aware there are about 8 videos that were produced of them filming themselves dragging files that cut in and out. There's about, don't quote me on the exact number, I believe approximately 9 videos from the Sallyport garage, maybe 12. I have not watched them in detail.
But have you noticed the quality? Is it something you can actually see, or is it blurred and?
I think some of them are at least the same ones. Some of them I think are blurry. I haven't watched them all in detail. I can tell you that they have the same file names as some of the ones that are produced. They have different file sizes, but I haven't gone through them in detail. It was 9:30.
All right, go
So-
ahead, Mr. Johnson.
Your Honor, just to close, I think that if I have overnight this evening, I think I can be ready by tomorrow. I'm generally ready. I just want to make sure I'm not missing anything, leaving anything on the
So
table.
what I was thinking by way of scheduling, we've gone through just about everything we need to go through today. I just wanted to, because it's about scheduling, what's the Commonwealth's position on Ms. Little's, or I assume it was Ms. Little's motion to filed by Ms. Little motion to reconsider my previous ruling on the videos? Do you want time to file something on that? Are you prepared to argue that today? Because I can tell you the options that I have for scheduling.
We've already downloaded the videos and provided them to yesterday pursuant to the court's directive.
Okay, so that was going to be another issue that I
I have not looked at them, Attorney Riley did, and he represented that they're all the videos we've already turned over, same quality as we previously provided. They're just copies of the same videos, although they do want to make sure the defense has an opportunity to examine them for themselves. But those have all been done, so the idea of revisiting that, we passed that.
All right, so in order to keep moving this case forward, because I know how hard everybody's worked, what I was going to propose, based on my review of this, because I could just say no, which I'm not going to do. I would like anything that the defense is going to put in writing. If you're going to supplement this, then I would keep the supplement just limited to the Sallyport video and related evidence. That has to be filed by Thursday with the idea that we will have a hearing on this on Friday. We have Friday already blocked off. This way here, you can all leave for today. And we'll come back Friday with this. But I'd like it filed no later than 2 o'clock on
Wait,
Thursday.
are they coming back
Massachusetts
tomorrow?
time. We've been getting things coming in later, including something from Ms. Gianetti after 5:30 one night. So we need things filed by that court day. So you can have anything that the defense wants to file by 2 o'clock Thursday, and we'll see you all here for it How long do you think it'll take to argue the motion to
Okay,
dismiss?
Your
somebody,
Honor, I would
I'm
expect my
having a
comments
hearing
just
issue.
based on
Can you
what I
tell me,
have
are
so
we having a
far,
hearing tomorrow?
an hour plus, perhaps an hour and 20 minutes, something like that.
Okay.
Toxic, do we have any of that
Commonwealth
new
response,
400
any
pages
idea?
of, oh, they have
Of
400
argument
pages
time,
of
Laura,
discovery.
it
Damn.
really depends on what the defense argues, but it typically is less.
So if we start at 11, we'll finish Friday?
Oh, of course, yeah, yes, I believe we will, for sure.
How does that schedule work?
It works for the Commonwealth.
I need to ask this little one quick question.
Let's
While he's
hold
asking
this
her
back.
that, that would mean that we do not have to appear.
I want to scroll it back just to here.
That were produced of them filming themselves dragging files that cut in and out. There's about, don't quote me on the exact number, I believe approximately 9 videos from the Sally Port garage, maybe 12. I have not watched them in detail.
But have you noticed the quality? Is it something you can actually see, or is it blurred and?
I think some of them are at least the same ones. Some of them I think are blurry. I haven't watched them all in detail. I can tell you that they have the same file names as some of the ones that are produced. They have different file sizes, but I haven't gone through them in detail. It was 9:30.
Oh, wait. Hear that again.
Your Honor, just to
Hear
clear,
that again.
As some of the ones, I can tell you that they have the same file names as some of the ones that are produced. They have different file sizes, but I haven't gone through them in
Okay,
detail.
so some of them have the same file names, but they're different file sizes, which means they were edited. If the file name's the same, tomorrow's the federal court. Right. Okay, good. Phew. But we have what I'm really freaking out over is she's sitting here saying the file names are the same, but the file sizes are different. That is not good. That's a no bueno. Thank you so much.
All right, go
So-
ahead, Mr. Johnson.
Your Honor, just to close, I think that if I have overnight this evening, I think I can be ready by tomorrow. I'm generally ready. I just want to make sure I'm not missing anything, leaving anything on the
So
table.
what I was thinking by way of scheduling, we've gone through just about everything we need to go through today. I just wanted to, because it's about scheduling, what's the Commonwealth's position on Ms. Little's, or I assume it was Ms. Little's motion filed by Ms. Little motion to reconsider my previous ruling on the videos? Do you want time to file something on that? Are you prepared to argue that today? Because I can tell you the options that I have for scheduling.
We've already downloaded the videos and provided them to yesterday pursuant to the court's directive.
Okay, so that was going to be another issue that I
I have not looked at them, Attorney Riley did, and he represented that they're all the videos we've already turned over, same quality as we previously provided. They're just copies of the same videos, although they do want to make sure the defense has an opportunity to examine them for themselves. But those have all been done, so the idea of revisiting that, we've passed that.
All right, so in order to keep moving this case forward, because I know how hard everybody's worked, what I was going to propose, based on my review of this, because I could just say no, which I'm not going to do. I would like anything that the defense is going to put in writing. If you're going to supplement this, and I would keep the supplement just limited to the Sally Port video and related evidence. That has to be filed by Thursday with the idea that we will have a hearing on this on Friday. We have Friday already blocked off. This way here, you can all leave for today. And we'll come back Friday with this. But I'd like it filed no later than 2 o'clock on Thursday, Massachusetts time. We've been getting things coming in later, including something from Miss Gianetti after 5:30 one night. So we need that filed by that court day. So
Including Mr.
you can have anything that the
God
defense wants to
almighty.
file by 2 o'clock Thursday, and we'll see you all here for it how long do you think it'll take to argue the motion to dismiss?
Your Honor, I would expect my comments just based on what I have so far, an hour plus, perhaps an hour and 20 minutes, something like that.
Okay. Commonwealth's response, any idea?
Of argument time, Laura?
Yeah.
It really depends on what the defense argues, but it typically is less.
So if we start at 11, we'll finish Friday?
Oh, of course, yeah, yes, I believe we will, for sure.
How does that schedule work?
It works for the Commonwealth.
I need to ask Mr. Little one quick question.
While he's asking her that, that would mean that we do not have to appear tomorrow.
Right, you're in federal court, I want you to be able to just go do that
Thank you.
and not have to come back here tomorrow.
Yeah.
And I'm trying to consolidate this now so you can leave it half a day today, rather than coming back. I'm just trying to make the best use of everybody's time.
Much appreciated.
That's
Your
a
Honor,
first.
11 o'clock would work. I think I can make my flight. By the time we get done, I can get it to you. That's fine.
All right, so where do we stand in the motion for reconsideration? Sounds like the files have already been provided and it's done.
Your Honor, we still would like to be heard as to that, obviously. We gave notice that we were seeking a motion for reconsideration on Sunday night. They did the download Monday morning after they had received that. There is still metadata, we believe, on the Canon PD drive. I think we're entitled to that. I think the law is clear. I would like to be heard on that issue. Obviously, we can't take back what they did. They have moved the files.
Oh, I
That's
agree
lawful metadata.
100%.
That's our expert declared his affidavit. It may be lost, but we'd still like to have as much
Yes,
information.
Diane, I
as
don't know if
it
you can
relates
hear
to
me.
those files.
So how long does the Commonwealth need? I know this motion is just filed.
Diane, we're going to go to another stream, so we're going to disconnect you here. Okay, she can't hear me.
I think we'll file a written response.
Okay.
We're gonna need a couple of days. If we have motions, then maybe Friday.
Yes.
So I think I'll make a motion in writing, but I think we will hope to have the weekend if the court allows, because with all of these hearings, it's taken away quite a bit of our time.
Right. Can you argue it on Friday and file a supplemental afterward?
I can do that.
That way then we can have everybody here Friday and I don't need to bring everybody back Monday.
We can do that.
Your Honor, I ask for the same courtesy for the defense. We have all of our reciprocal discovery due on Thursday. We have all of our motions and we meet on Friday. I know the court would like us to have, the brief as to the motion to dismiss on Thursday, and I would love to be able to get the court that. But I would appreciate a little bit additional time as well.
So I need to know how this affects the motion to dismiss them, right? We need to, you've had this since, so you've got these recent ones. But I need to know how that, are you going to argue that in the motion to dismiss?
Well, I don't know because we got it last night at 9:30, so I wish I could answer that for the court, but I'm in a bit of a catch-22. It might be irrelevant, it might not change anything at all. I won't know until I have a chance to actually go through everything.
But I need something, right? I need to know that Thursday. It doesn't have to be a complete report, an outline even, would the Commonwealth be satisfied with an outline? Know what the points are?
An outline of what you are.
Of what Ms. Little says, how this disclosure of, this late disclosure of videos.
Sure, we'll deal with it.
All right, so if you just so that I know the points that you're raising for the motion to dismiss, and then I want to supplement it very quickly thereafter. I have to decide this and put something right. So I need it to be done as quickly as possible. We've got a team of lawyers. I know the lion's share of the writing appears to be on you, Ms. Little, but there's everybody here that can help.
Yeah, 1 minute.
Okay, we're going to zoom a little bit because we got another trial that we're going to go into.
Right. Her key was the waiver. I'm not waiving anything on Ms. Reed's behalf, but if we need additional time, we can certainly let the court know tomorrow that we can file something supplemental. But the crux of the argument can be made tomorrow. I will be ready to argue tomorrow.
Okay, what's the Commonwealth's position?
They got a lot of work to do today, y'all. So, Miss Diane, when this is over, I'll send you the link to the new one.
More complications with defense travel will.
I can send it now. I don't know why I'm
I
waiting.
think we did log off today and tomorrow, with the understanding that the defense team would not be here sometime 11 o'clock or later.
Not what I want. I want to invite.
What about, Ms. Little, the motion regarding the metadata? Commonwealth needs time for that. Are we coming back Friday for that?
That's fine, Your Honor. I'll be here on Friday.
If you're going to be here on
I
Friday,
just won't be here on Friday.
Oh, my Lord, have
If we
mercy.
do the motion
Bingo!
to dismiss tomorrow,
Diane.
I can head back tomorrow evening. And Mr. Little will handle her motion anyway. I'm
I greatly want to accommodate the defense as we have the entire time we've been here, but we have trial prep to do as well. In more court hearing days, we have hours of conversation, the more time we can meet with witnesses and prepare our case. And so I want to make things as easy as possible for the defense. I do.
All right, so Ms. Little already filed the motion for me to reconsider. Why don't we hear that tomorrow as well?
Very well.
Okay, and then we'll just finish up everything tomorrow.
Very well.
All right, and then you won't have to be here Friday, but the motions in one day are all filed. It also involves filling out a trial conference report. So
Understood.
we need to do that as well. That all has to be done by Friday.
Understood.
And then, my goal was not to bring you back one day at all next week, because then we're gonna have a full hearing. I believe it's the 18th, the motions in the minute.
That's right, the 18th.
All right, so we have a whole week next week to, you and I both, try and get everything done.
Should we file a formal motion to ask the court's permission for delay from Friday till Monday?
For the.
Oh, God almighty.
The Commonwealths were due on, the defense were due on Thursday, Commonwealths on Friday. Were they all on Friday?
Reciprocal discovery is due Thursday. We want that to happen. Motions eliminated, I believe, to do Friday.
Ms. Little, would you like the weekend for all those motions eliminated?
I would appreciate that, Your Honor.
All right, I'll give you both the weekend.
Thank you very much.
Motions eliminated to be filed on Monday.
There's one additional housekeeping, Your Honor. There is also a motion pending, the dollar motion for Dr. Wolf. It has not been heard yet.
A Daubert motion for?
Dr. Wolf is a neurologist. So there's
Oh,
one
I
additional.
was thinking the Akron.
No, Your Honor, it's the neurologist of the Commonwealth. Wolf without an E, WOLF. That was filed, 2 weeks ago, I think.
I have not seen that.
Okay. I'll make sure that the court gets a copy, but I know that was filed several weeks ago. I'll confer with Mr.
The Commonwealth must have received it.
We did. We have a Wolf as well, and I received their amending motion, and we'll be prepared anytime to argue that.
Do you want to argue it tomorrow?
I'm comfortable arguing tomorrow.
We're prepared.
All right, so we've got an awful lot to fit in tomorrow. All right. If you get word that you'll be leaving the federal court and can be here before 11, please let us know.
I believe I might have Mr. McDermott's cell. I'm happy to text him as soon as we're leaving the courthouse.
All right, just don't contact the clerk's office.
Sure. Okay.
Anything else for today then?
Not for the defense, Your Honor. Thank you.
Sorry, y'all.
So I'm gonna give you all a, why don't you fill out all the signs, I'll be out to subscription.
What's the call, Riley, please?
What was that? Okay, I guess we're done with her. All right, guys, before we get going, I will do the drawing for this particular live stream.
And we want to change it to, we did.
I'm going to stop sharing that. I'm going to share this. I'm going to go over here. Let me get everything. I've got so many pages up right now because I'm prepping, getting me ready. I share this. Nope. That's not what I want to share. I'm over here. Give me a minute, y'all. This is just going. Get rid of that. Yay! Got rid of that. Okay, now I need to. Where are the other pages? There they are. Share this in StreamYard. Come on. Wrong one. Remove. Here. Let me see if I can get this in StreamYard. No, it's sharing in the wrong place. Okay, it's sharing in the wrong feed. So I will just screenshot it and tell you. All right, let's see who won this one. It's sharing in the Monica Simatilli prep and not this prep. Nope, I can't win. You don't want me to win? No. Chris H, you won. You are in the end of the month entry. You won an entry. I'm going to share StreamYard. This one, I finally got it to share here. There we go. So let's do this one. Dun, 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 dun. I didn't get the music going. Dawn, you won an entry to the end of the month giveaway. Yay! Okay, guys, when I end this stream, this is going to catapult you to the Monica Simatilli trial, which has not started yet. I was surprised. It should have already started, but they're gearing up. This has been perfect timing. So thank you again for joining me for the Karen Read. We will be here tomorrow for the Supreme Court part of the Karen Read stuff. And then again Friday, all day Friday. So thank God it went as well. I think it went well, but I still don't believe Auntie Bev is going to give anything to the defense. Although I think they handled themselves quite well. I'm really liking Brennan. He's awesome. Not Brennan. I'm sorry, Jackson. He's awesome. Okay, guys. I will see you at the other stream. Bye. Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.